pensioning slip.
My lord, for upgradation, my lord, item number.
না আর্জেন্ট আছে বললো ব্যাংক অ্যাকাউন্ট অ্যাটাচড হয়ে গেছে, দেখুন লেখা আছে।
My lord, item number 371, my lord, of the day's list, my lord, for upgradation, my lord, my statutory appeal was dismissed on ground of limitation. My lord, subsequently, my bank account has been attached.
Yes, give it.
My lord, may I permitted to
Let me, my lord.
from the determination of Justice, Honorable Justice the urgency is that my grandmother's property has been declared as enemy property by the custodian of the enemy property, and my grandmother has been declared as Pakistani citizen.
What is the urgency there? You challenge it, you have challenged it, will be adjudicated. No urgency, it can wait till Monday. What will happen in between this? Monday, the regular bench is coming, yes.
One matter, another matter is still in the random right? Matter was heard by Honorable Justice Raja Vasuki, and election was given from the HON'BLE from whom I have purchased in your lordship. They are not issued the declaration.
দিদি দেখুন তো এটা কেন ফাইল আসছে না, কেন ফাইল আসছে না বলছেন?
Lordship, may I be permitted to mention?
May I permit to mention, my lord? Respondent grabbed my land without any notice, and no compensation has been given till date, my lord.
Monday the bench will be available. Yes, madam.
Your lordship, I have mentioned it earlier, 3 matter, your lordship, where the recovery notice has been initiated and final reminder is also given.
এনার কেন আসছে না ম্যাটার গুলো দিদি? উনি আগেও মেনশন করেছেন। আর্জেন্সি গ্রাউন্ডে রোজ রোজ একই জন মেনশন করছে, কি ব্যাপার?
Lordship, yesterday I had mentioned this matter for extension of interim order. My interim order is expiring on 19th. Lordship had directed the matter to be appeared today, but it is appearing, but item number 706, Lordship.
Wait, দিদি এনার আইটেম 706 এটা এক্সটেনশনে মেনশন করেছিলেন, এটা লিস্টে আসছে নিচে।
Yesterday I mentioned গতকাল।
Write the item number there in the slip and give it.
It is written, Lordship.
Give
আজকে 706
এক্সটেনশনে দেবেন এগুলো। এগুলো একটু নজর রাখুন, বারবার একই জিনিস মেনশন হচ্ছে, আমারও অসুবিধা হচ্ছে, আপনারও হচ্ছে। ইয়েস,
grateful. স্লিপটা লাগবে?
Yes, yesterday it was there, na? মানে similar matters were heard yesterday. It is those matters, one of those matters where costs were posited to.
You challenge the adjudication of the council violation of principles of natural justice.
444 দিয়ে দিন, আর্জেন্টে দিয়ে দিন।
One indulgence. This matter for the different assessment here already heard by Honorable Justice Raja Vasuki and was held in favor of the denial. Analogous matter, different here.
Lordship, under the compelling circumstances, Lordship, may be allowed to mention one matter, Lordship, group 1 matter, land matter, Lordship. Urgency is that, Lordship, the petitioners initially was, Lordship, the roadside encroachers. They were, Lordship, under the indulgence of the government and the district authority of the Howrah district. They were shifted to a particular place, Lordship, land. The rehabilitation that was granted, Lordship, in 2000. But, Lordship, the land in which the petitioners were, Lordship, deployed, in which the petitioners were rehabilitated, that was the private land. But, Lordship, the entire process that was being carried out under the supervisions and direction of the, Lordship, the district magistrate and collector of the Howrah district. Laterly, Lordship, the petitioners, literally the owner of that particular lands where the petitioners were rehabilitated, they preferred a petition, Lordship, and there was a direction given by the coordinate single bench that the petitioners, they should be evicted from that particular place, but after giving rehabilitation. That rehabilitation that was not given to the petitioners. That is the claim, Lordship. The urgency is now, Lordship, that they were, Lordship, forcefully evicted by, Lordship, that they attempted by the district administration to evict the particular petitioners, despite they have not been, Lordship, rehabilitated. This is the urgency, Lordship. Kindly, Lordship, take this matter.
Monday the regular bench will be available. Yes, madam.
Mentioned service tax, and it is that the petitioner has paid for matter of hearing on 3rd December 2025, but it has not appeared in the court list. So
You want it to be listed?
Yes.
দিয়ে দিন, লিস্টে দিয়ে দিন। চলো কল করুন।
My lord, item number 3, I am appearing, my lord, virtually.
Yes.
Now, in this case, my lord, the entry order is expiring in December 2025, my lord.
Your affidavit
And
is
there was,
replied to the
my lord, I shall be candid, my lord, I am misplaced, my lord. Therefore, my lord, I could not file. My lord, kindly allow me 4 weeks time, I will file, my lord. And 20% of the tax in dispute I have paid, my lord, for stay, my lord, as per the court's order, my lord.
What is it? 20% you have paid.
Yes, yes, my lord. Since the tribunal has not been constituted, my lord,
You were
in the
directed to
first
pay.
call, yes, yes, I have been directed by this honorable court to, my lord, pay the 20% for stay, my lord.
Very well. This matter is appearing under the heading extension of interim order. Upon being mentioned, therefore, full stop. Heard learned advocates appearing the respective parties, full stop. The subsisting interim order, which is to continue till the end of December 2025, is extended till the
My lord, since I have paid, my lord, 20%, my lord, till disposal, my lord, if your lordship may guide.
আচ্ছা ওখানে
Uh,
তার আগে তাহলে লিখে দিন it is submitted by Mr. Dugar, learned advocate appearing for the petitioners, that the petitioners have already deposited a sum equivalent to 20% of the balance disputed tax in terms of the order dated December 6, 2023, passed by this court. Full stop. Paragraph. Mr. Chakravarti, you know he has deposited.
But if my reference saying in first term.
my lord, lordship may record my,
Very good. Record করেই দিলেন তো ওনার সাবমিশনটা রেকর্ড করলেন ফুল স্টপ in such view of the matter comma let the in such view of the matter the interim order which is to continue till the end of December 2025 is extended till disposal of the writ petition, full stop. Mr. Dugar prays for extension of time to file affidavit in reply to the affidavit in opposition filed on behalf of the respondents. Let such affidavit in reply be filed within 4 weeks from date.
I am grateful, my lord.
List this matter for hearing in the monthly list of February 2026. I
I'm
will send
grateful,
you
man.
the disposal.
I'm grateful. In the next matter, my lord, interim order is going to expire, my lord, in December 2025, my lord, and department has respondent authorities are, my lord, supposed to file the affidavit in
Mr.
opposition. my lord.
Chakravarti, your affidavit? You are not there.
Item number 4.
Yes. No, you are not there.
Mr.
Union of India is
Somen Bhattacharya, Union of India is a party.
Mr. Dudhoria, Mr. Bhattacharya is not here. Liken in order. This matter is appearing under the heading extension of interim order. Upon being mentioned, therefore, full stop. এখন ওই none appears টা লিখে রাখুন যদি আসে তাহলে কেটে দিন none appears for the respondents, full stop. The interim order which is subsisting and is to continue till the end of December 2025 is extended till the end of February, 2026. list this matter for hearing in the monthly list of February, 2026. করার নেই। এলে দেখা যাবে। Mr. Dugar, if Mr. Bhattacharya turns up, I'll record his name, and instead of none appears,
Yes. I'm good. Item number 5, I am appealing, my lord. Here also, my lord, I'm praying for extension of interim order.
Mr.
Leave,
Chakravarti, you are
and
appealing
time may be extended.
extension of interim order, it's appearing, and your reply is still not
No,
here.
my lord, yes, my lord. Bunch, my lord, I misplaced, my lord. That's why, my lord, I will request my learned friend to
Here
take, my
also,
lord.
it's a question of 20% deposit or no?
No, my lord, here we have not deposited. Unconditional interim order was granted, my lord.
Then I'll extend it
Because,
for a limited period.
yes, my lord.
ওই প্রথম তো সেম থাকবে, this matter is appearing under the hearing যা থাকছে, তারপরে লিখুন Mr. Dugar, learned advocate, appearing for the petitioner, seeks some more time to file affidavit in reply, full stop. Let such affidavit in reply be filed within 4 weeks from date, full stop. The subsisting interim order, which is to continue till the end of December 2025, is extended till the end of February 2026. List this matter for hearing in the monthly list of February 2026.
I'm grateful.
Let him come.
May I leave, my lord?
Your Lordship, the interim order is expiring in the month of December 2025, and there was a direction for affidavits, but we are yet to receive the affidavit in opposition from the respondents.
Mr. Chakravarti, you are appearing. Same উপরের লাইনটা সেম থাকবে। Mr. Chakravarti, learned advocate, appearing for the respondents, seeks extension of time to file
May it please, Your Lordship.
I'm appearing for respondent number 2.
Your Lordship, and this,
What about the respondent number 1?
Your Lordship, we've filed this writ petition challenging non-grant of refund, Your Lordship, under the Income Tax Act. What has happened, Your Lordship? This matter is arising out of interpretation of a particular provision of the double taxation avoidance agreement between India and Japan. The petitioner, Your Lordship, is its head office is there in Tokyo, and it is also has a registered office in Kolkata. So it is carrying on marine business. Your Lordship, this is a very old assessment year. Financial year is 87, 88, 88, 89 is the relevant assessment year. Your Lordship, what had happened that time was that it carried on the business in India. So there are certain income which is accrued in India, and it filed its returns, Your Lordship. And it also there was this particular provision under the double taxation avoidance agreement which provided that, Your Lordship, that where they're carrying on, where this income is accruing in India and in Japan, then, Your Lordship, the assessee will be entitled to 50% of the deduction. That was the provision in place. Your Lordship, the income was assessed, and this particular deduction was allowed. Of Your Lordship, the amount is 23 odd lakh. It was allowed. Thereafter, Your Lordship, the assessment order was revised under Section 263, Your Lordship, CIT appeal. And your lordship, after that, your lordship, this deduction thereafter, it was further assessed and this deduction was not allowed. Then the matter traversed up to the CIT appeal, your lordship. There again, it was held against the assessee. Then the assessee appealed and before the tribunal, your lordship. There also it was held against the assessee. Thereafter, your lordship, a miscellaneous application was filed on the ground that there are certain errors apparent on record. Your lordship, considering that application, the tribunal allowed the deduction in favor of the assessee. So the earlier order, which was against the assessee by the tribunals, stood modified to that extent. And this particular deduction was allowed, your lordship. I will come, your lordship, the interpretation of that provision earlier, it was disallowed, saying that during this year, what happened, your lordship, in Japan, the assessee had shown a loss. There was a world loss. So the interpretation which was given by the authorities was that since there was there was a negative income or loss and no tax was paid in Japan, hence this particular deduction will not be allowed. Thereafter, your lordship, the interpretation which was subsequently which was upheld by the tribunal was that the DTA provision nowhere stated that tax has to be paid over there for the deduction to be allowed. And if there is a clash between Section 90 of the Income Tax Act and the DTA provision, then the DTA provision will overpower that, your
So
lordship.
what is your immediate challenge
Yes,
here?
yes. Thereafter, your lordship, what had happened is that after the tribunal, the order stood modified, the department had filed an appeal. That time, your lordship, the reference provision was there. So they had gone up in reference. Ultimately, the matter was taken up by the division bench of this honorable court, where, your lordship, the department had withdrawn because of the monetary effect circular. They had withdrawn and the appeal was dismissed as not pressed. Your lordship, that was in 2019. Since then, we have not been granted the refund, which is admittedly, your lordship, that we are entitled to the refund. After that, your lordship, we have filed several representations, 3 representations, your lordship. As per my instruction, the department hasn't replied to that, your lordship. We are yet awaiting a case of an admitted refund of this 23 odd lakh. If you're now, your lordship, I may take your lordship to the papers, your lordship. I would, your lordship, take your lordship to the straight away. I can take your lordship to the miscellaneous application. That is where your lordship, this claim was allowed. Or should I take from the assessment order? Show the relevant.
You show me the application which you have filed before the
Yes, your lordship, will, that application is not made a copy, your lordship. The miscellaneous, the order is there, your lordship. If
No,
I
you
may.
haven't made any application seeking the refund.
Yes, those are there, your lordship. I was just
How have those been disposed of?
no, that is not there. That
So
is
then
that
we'll
is the
consider it as a-
subject. It was heard at length, your lordship, by Justice.
Lordship, can you page number 50, the application was there, but thereafter, application date was June 6, 2023. Thereafter, Lord, on 19th February 2024, he was asked to produce some documents. He did not produce those documents. On 19th February 2024. I'm also handing over to him the copy, Lord. That is my.
On instruction, your lordship, I have not.
It's a DIN number is there, so it is online. It's there.
I am not aware, your lordship.
Can pass the order to dispose of the application. So you have to cooperate.
Your lordship, there is no question of non-cooperation. There are 3 representations I filed. The assessment year is 88, 89, your lordship. But I do not know, your lordship. In February 2024, they have put whether we have missed or not. On instruction, your lordship, I am submitting that I have not received this. So
Which
as per
document
my
you haven't received.
no, this is my instruction, your lordship. Now he's giving me a copy.
So now
I
you
will.
have received, can
Yes.
you take instructions on
Yes,
this?
I will, your lordship. I can take instructions on this. Your lordship would kindly keep the matter, then after vacation, your lordship, I will
Very good.
reply to this.
Or should I dispose this of, say, নানা পেজটা ওখানে লিখে দিন, মিস্টার ভট্টাচার্য, learned advocate appearing for the respondents, seeks extension of time to file affidavit in opposition. Let such affidavit in opposition be filed within 4 weeks from date. Reply thereto, if any, comma, within 2 weeks thereafter. আর ম্যাটার তো মান্থলি লিস্ট অফ ফেব্রুয়ারি বলাই আছে, এক্সটেনশন টিল দি এন্ড অফ ফেব্রুয়ারি। ইয়েস,
Well, I have the petitioner, my lord.
ইয়েস।
Well, this is a similar matter, my lord has nine. Call দেখলাম বাইরে নাই।
My lord, in item 8, I'm led by Mr. Churaria. He's on his legs before the circuit bench, my lord. Kindly keeps it next week.
After vacation. After.
As prayed for by the parties, list this matter on January 6. You have the earlier order, not yesterday's order, the one which was passed
Yes,
by.
my lord, I have.
Yesterday's order will be uploaded today.
I only remember the 50,000 cost.
On that day, my lord, learned friend has impressed the court that 50,000 has to be imposed. I couldn't say anything.
With the status of the account.
No, no, no.
Commensurate with the status of.
ওই আগে যে অর্ডারটা পাস হয়েছিল না, কালকে একই রকম 4টে অর্ডার Isur.
Yes.
Regarding my cash seizure during inspection, and last this matter was heard on 12th of December 24. Then my learned friend took time for instructions. After that, it has been again heard today. Lordship's your lordship's order I have brought.
Yes, but there was a report there.
I'm not challenging anything. I'm only saying that they cannot seize cash under 67(2).
No, they can seize. I have held that they can seize only
If it is not for the use of investigation.
Yes.
Lordship, I have brought a compilation.
it shall be useful for.
Lordship.
I have quoted it from the section.
Lordship's order. Lordship, in my case, since the investigation was done, Lordship may kindly take, the summons was issued on 1st of October 24. After that, nothing. Till today, no show cause, no proceeding, nothing, Lordships. In fact, I was arrested.
Very well. Where you file your report? When can you file?
7 days, Lordship.
File it before the vacation, so that
Before the, I want to
Yes.
before the
because I need something on record to record that it is not relevant.
it is relevant for the investigation.
Yes.
Yes.
Without that,
Lordship, the legal provision, Lordship,
And
says
another thing
court
is that recently, I have the judgment, though the Honorable Supreme Court accepted this and grant the stay, but that issue now before the Supreme Court in the case of Commissioner CGSTs versus Bhagwan Gupta. In this case, Delhi High Court has directed the department to forthwith release that case. Now, department has challenged before the Honorable Supreme Court, and the Honorable Supreme Court has, if your Lordship, just for your Lordship, consideration. And here the Delhi High Court's order in HON'BLE versus Commissioner that was referred. The Supreme Court has granted stay and directed for serve of the notice. That the matter is pending before the Supreme Court.
This operates, Lordship, only between those parties.
No, I am not saying that. I am saying that now.
No, of course, what
I
you
am
have
not
told us.
saying for my
Lordship, in fact,
that is
Deepak Khandelwal, which your Lordship relied, that the review against that was also dismissed.
in spite
The
of
review
in
also.
spite of that, my lord, the Supreme Court has
Maybe
entertained this.
it was-
I don't know what are the facts.
Lordship,
Yes.
Facts.
No, I also can keep that Delhi High Court's order if your Lordship.
When you will file your report later.
Yes.
Things, that is one thing, whether it can come under the phrase things, and then the usefulness of.
Yes.
Madhya
What
Pradesh, I
purpose
could
of
have said,
Anything, even if
Madam,
it comes
Madhya
under it,
Pradesh,
it
I
has
could
to
have
be,
said,
it has to be,
Yes.
useful for the purpose of investigation.
yes, that part
phrase-
I underline
Lots,
in
sir,
my
highlighted.
order.
but Madhya Pradesh, I could have said things include cash also.
Yes, yes, it will include.
Mm.
I have not said that it will not
Sir,
include. I
usefulness.
underlined it
Oh,
because
yes.
if you see the section, if you see that section,
67.2 Lordship, the usefulness in the investigation.
and that was the purport of the Delhi High Court's
Last.
order also. If you see section 67, 2,
Shall be useful for or
if you
relevant to any
see
process.
any goods liable to confiscation or any documents or books or thing thereafter, which in his opinion shall be useful or relevant to any proceeding under this act. So if it is useful for any proceeding under some other act, then he will not be able to do it. He has to show that it is useful for any proceeding under this act. That was the
That is
crux.
And these judgment also distinguished by the Kerala High Court, whatever the Delhi High Court and Karnataka High Court, Gujarat High Court. Already distinguished. Kalishka Mata, already distinguished. Yes.
Yes.
My lord, this was matter item number 11, my lords.
Yes.
Matter was heard last on 8 December, my lords, but
Yes,
directed
there
to
was he
change
had
to
amended the cost.
amendment. Yes, my lord, we have done that, my lords. My lords, I'll just briefly summarize the issue. My lords, we are the mine. My lords, I am a mining contractor rendering services to Central Coalfields Limited. My lords, our services are we are crushing the coal and loading on the trucks and transporting. So, my lord, two considerations we are receiving. One for crushing of coal, on which we are paying 18% GST as auxiliary mining services. Not in dispute, my lords. The transportation service that we are rendering, on that, my lords, the Central Coalfields paid tax under reverse charge mechanism 5%. My lords, this was a DGGI investigation against all these contractors who have got this job from Central Coalfield and other coal mining companies. That, as per the interpretation of the DGGI, my lords, all these services are bundled services on which tax should be paid at the rate of 18% by the contractor, not the these should not be vivisected as per them. As per the DGGI investigation, it is a composite service. My lords, once this investigation happened, my lords, Central Coalfields, although there are judgments, precedents, etc., in the pre-GST law which support us. However, because this is a revenue neutral situation, whatever tax is paid is availed as a credit by the CCL. CCL took a stand that they will not agitate this point. They will pay the remaining 13% tax also and get done with this investigation. My lord, that is what they did in my case also. The period involved is 1920, my lords. Although, my lords, there are other issues like whether the order is barred by limitation because this is another extended time period as per the notifications, my lord, which are still agitated before my lords. So I'll not go into that, my lords, for the simple reason that the entire tax in dispute has already reached the government. So there is nothing that any government is not short of revenue in this matter. And matter in the interest of justice, my lord, what happened in this matter? They issued the show cause notice and the orders towards the end of the timelines prescribed. And my lords, in the show cause notice that was issued on 26th May 2024, my lords, they gave me time till 1 month for filing the reply. My lords, by that time, my business has already closed. This contract with the CCL had come to an end, and I was short of manpower, etc. The sole person who was in charge and looking after the affairs of the company, my lords, of this joint venture, my lords, he was in a difficult medical situation. I have enclosed his medical certificate, etc. He was suffering from chronic back pain, etc., and was hospitalized for most of the time. We could not participate in the proceedings, my lords. They issued the show cause notice and one hearing. I could not file the reply and attend that hearing. They passed the order towards the just 1 month before the timeline had to expire for passing the order. Lords, in these set of facts, my lords, my only humble prayer is allow me to go back to the authority and produce the certificate of the CCL. I have enclosed the certificate also on record, my lords. Already tax has reached the government. That is my humble prayer, my lords.
Yes, Mr. Chakravarti.
A joint venture company, two companies. This is not an individual who is ill or it's a two companies. Joint venture is practically a partnership of two companies. One person ill, 2024 order, 27th August.
Why was your appeal dismissed? Delay.
Appeal, I never filed the appeal, my lords, because I could never
directly
participate.
against the adjudicating order.
Yes, my lords, because I could not participate in the proceeding, my lords, and in similar circumstances, my lords, even for the companies, just my learned friend is suggesting that we are joint venture, etc., not individual. For companies also, my lords, similar reliefs have been given by this court and the other high courts, my lords. I can place the decisions on record, my lords.
Against adjudication.
Yes, my lords.
Orders.
Yes, my
Show me.
lords. My lords, page number 15, my lords. The order starts at page 14. Karnataka High Court, Jyoti Polymers, my lords. Para 3, page 15. May I read, my lord? My lord, para 3, 5, 6, and 7 are relevant, my lords.
This was under review, additional notices and orders.
My lords, reasons
There was
for
the reason why
My
the
lords,
court intervened.
My lords, in my case also it's under review additional notices also only. My lords, reasons may be different why a person could not participate in the proceeding, my lords. I'll show other judgments also, my lords. And my lords, please see para 5.
No,
What is
reason may be different, but reason has to be palatable.
My lords, please.
Whether your reason is palatable or not is the question.
My lord, para 5, my lord, please refer para 5 also of the same order, my lords. Where the respondents
Let us see what your reason is. Let us not go by the reasons of somebody else. What is your reason and how is it palatable?
Yes, my lords. My lord, my reason is that 2023 the business closed.
Where is it?
My lord, para 5 of my pleadings, of my page 5.
Your reason is only illness of one person.
Yes, my lords. And well, business had closed in 2023 and we are not conducting any business. My lords, 24, they issue a notice, etc. and giving only one opportunity, that too in the notice. No separate, no further intimation, etc. My lords, towards the end of the period of limitation. My lords, that is what had any, only after giving one notice wherein they have mentioned the date of hearing and reply, they have passed the order, my lords. So, my lords, I may only be, I'm a...
No, that's right. But after getting the order also, you have waited for so long to come to the writ court.
My lords, we were never aware of it. We have mentioned that also, my lords, because...
Where have you mentioned?
Yes, my lords.
Paragraph 8.
My lords.
Paragraph 8.
Para 8, my lords.
Page?
Page 7.
Page 7 at the end, my lords.
Last paragraph.
Additional notices and order stuff. So this ground, Mr. Chakravarti.
But this is not a ground. Can you see he doesn't
Why not?
8,
My lord,
8
para
he
8, my lords, para 8.
But I could have understood when his 8 is the clarification.
7, 8 both read together, my lords, basically.
Okay. 7 and 8 read together say the same. Why kill him without hearing him?
No. Oh, January 2024, the portal has changed. But we had shown that the show cause notice was issued on 28th May 2024.
When was the show cause notice issued?
28th May 2024. Page 63. Judgment about.
Very well. There are so many reasons.
But
illness and all.
I do not.
He'll pay some costs. He'll pay some costs.
Yes, pay some cost.
Let him pay some cost.
My only request, my lord, may please be a little generous with,
Yeah,
because
my
these
lord,
are small
I
time,
have
small time
this
JV.
precedent and this will be
That's
followed. My lord,
not,
that is the difficult. Well, individual cases I never oppose.
my lord, this
Very
is
well.
like individual only.
Didi, the petitioner, now this writ petition, this writ
in the knowledge is there with the department. They have been informed. Several other assessment years, they have acted upon it and they have not proceeded. But this assessment year, even after informing, they have acted and passed out Section 147 order. That is under challenge before my lords. This is my
Assessment
affidavit.
order has been passed. So
Lordship.
why are you coming here then?
Because,
Go
Lordship,
in appeal, you will get
Lordship,
this opportunity.
that there is no assessee, Lordship. The assessee is not there. The assessee has died. And it has been
Against a dead
informed.
person?
Yes, Your Lordship. It has
Who
been
is appearing for
informed.
the department?
Should I have my affidavit of service? Not no. कोई तुम्हारा joint commission judicial case. But let it appear tomorrow, my lord. You can come back tomorrow.
Well, not today, sir.
Only not.
Not today.
We'll come back.
But I have the petition, my lord. It was heard on 22nd September 2025. But the issue is, my lord, that the petitioner's credit ledger was search and seizure was conducted in the business place of the petitioner in the month of January 2025. Thereafter, we have filed a reply and we have deposited 2 lakh rupees. Then the credit ledger was blocked in the month of March, 4th of March 2025. Till late, then thereafter, we have filed a representation before the authority in the month of May, 15 May 2024, 25, madam. Then several representations, last representation May 15, 2025, madam. Then
The issue, just to cut short, the representation should be considered.
Madam, they have considered my representation. Just only my representation has been considered. Madam, they have partly. Madam, they have kindly see the copy of the order. Well, the issue, the present issue is, the other High Court has held, some of the High Court held in favor of the assessee, some of the High Court held in favor of the revenue manner. That is quoted in the order itself, my lord. My contention before the lordship, my lord, I am ready to pay 20% of the determination, the present determination made by the authority concerned. Let the matter be hard. In the meantime, they release my credit ledger, my lord. To kindly come to page 40 of the writ petition, last paragraph. Under the above circumstances, the RTP's credit ledger had been debited temporarily of rupees 28 lakh 95,427.
Paragraph 40.
Page 40, my lord, last paragraph. Page 40 of the writ petition.
Page 40, yes.
Yes. Under the above circumstances, based on the finding and discussion made above, the credit of input tax amounting to the extent of rupees 28 lakh 95,000 in each head of CGST and SGST in the electronic credit ledger has been fraudulently availed or ineligible to the RTP. Therefore, the RTP is not eligible to debit ITC referred to above following provisions of clause A, B, and KB under subrule 1 of Rule 86A of the GST rules. Under the above circumstances, the RTP's credit ledger had been debited temporarily of rupees 28 lakh 95,427 in each heads as per such and such for discharge of any liability under section 49 or any claim for any refund of unutilized input tax credit. Whereas credit ledger was blocked in the month of March 2024. Till date, there is no adjudication. They have not issued any so-called notice. They have to pass the order, my lord. They cannot hold my credit ledger for a long period of time. I am ready to pay my humble submission before lordship. When I am ready to pay of 20% of the disputed tax as admitted by the authority concerned. I could not file my return, my lord. Periodic return, my credit ledger has been blocked, my lord. But Rule 86 has been quoted in page 40 of the petition, my lord.
Rule 86A has not been fully quoted. They have only quoted the.
Yes, Malad, may I please, Malad?
I have it here.
What court has held, there Bombay High Court has held differently. Our court has held, division bench has held, negative blocking is permissible. That is by Honorable Chief Justice.
And the notice was issued by the Honorable Supreme Court.
Notice, this issue, in the meantime, my lord, this issue, it will take some time. It will take some time because there is already a division bench of our court. Some respect, possibly, my lord, cannot distinguish a division bench of our court, subject to correction, possible.
No,
But
division bench will be binding.
No, my lord, there is, my lord, subsequently, that has been our High Court judgment has been distinguished, and the Honorable Supreme Court is one of such cases, has the department has preferred an appeal.
Till it is, till it is set
Well,
aside
it
in
is.
the precedent. That is the law, my lord. That if it is
Well,
stayed also,
my submission before Lordship, my lord, they have credit ledger has been blocked in the month of March 2025. Well, today we are in December 2025. Almost 7.
may come back with this instruction, whether with 20%, my lord, will
It can be unblocked.
because my lord, the statutory scheme is 10% or 20%
For filing appeal.
for finding appeal or any for a finding appeal. So, my lord, may come back with this instruction by Monday.
Come back.
And let us cross swords on this issue, my lord, or this principle of law.
Well,
some other
if
time.
my lord is learned friend is agree, well, then I can place my case.
Sure.
সময় লাগবে ছুটির আগে তো
Problem is the vacation time.
that is why otherwise
লিখে নিন তো।
It's an interesting point, man. It's a very interesting point.
Yes, it is there.
Well, I think it is in the file also, my lord. I have.
Revenue he has given.
What is it?
Yes, yes.
এটা 10%
এটা ফেরত দিন।
Well, we have already supplied all the copy of the
On I'm keeping this on Monday. On 22nd, Didi.
grateful one.
আমেরিকা থেকে নতুন ট্যাক্স
My lord, when on the last occasion when this
Yes,
matter
this
was,
was that matter, no?
yes, my lord. My lord, I had then submitted, my lord, that this particular 21607 also an identical matter, my lord, that is 214. My lord, 21640, they were tagged together. Suddenly, my lord, and identical, my lord, the order is also same, only different years. Suddenly, I found, my lord, it got detached and it is appearing as serial number 62 in today's list. So I'm only praying, my lord, if these two can be tagged together and it can be taken up tomorrow.
ঠিক আছে।
I'm giving it to the court officer, my lord.
দিদি, এই যেটা উনি দিচ্ছেন ওটা আর এটা একসাথে না, উইথ করে করবেন না। হ্যাঁ, কারণ কালকেরটা উইথ এখনো সরেনি, ওটা আপনি ডাকেননি ওই ভদ্রলোককে আমার কাছে। তো করছে কেন? যখন আমি অর্ডারে লিখে দিয়েছি আলাদা থাকবে।
My lord, it will appear tomorrow, my lord.
Yes,
I'm grateful.
হ্যাঁ, এটা পাঠাবেন আমাকে।
Well, this matter, you were supposed to take this decision. I had a talk with the highest officer, but it will be taken care of. Everything will be done. Kindly keep this matter on Monday as to be mentioned, it will be done.
ঠিক আছে।
Already heard last word.
As prayed for by
to by email to them also hard copy madam today itself.
And for the petitioner, your lordship.
GST? Yes. What is your problem, madam?
Your lordship, here the registration of your petitioner has been cancelled on non-filing of return, on the ground of non-filing of return. Your lordship, the petitioner was ill and he was not in a position to run the business properly, your lordship. That's why he didn't.
The similar orders were passed, you have?
Yes, lordship, but right now I don't have, yesterday only.
Yes,
So
that I
I
remember,
have
but
seen your lordship, but the order was not yet uploaded, that's why.
it will be uploaded today.
Yes, your lordship.
You don't have
that-
any copy of the order? There are other orders also before this.
Yes, I do have also the similar order, your lordship. I will give it to them.
No, it will be easier for me to dictate then. লিখে নিন দিদি। When you come to court, come ready so that things make things easier. দিদি যখন বলবো কাকে ডেকে দিতে ডেকে দেবেন, আপনি আপনার কাজ নয়, দরকার নেই। আমি যখন বলবো যে একটা কাজ করবেন সেটা করে দেবেন, নাহলে আমাকে এসে বলে দেবেন আমার কাজ নয়, আমি অন্য কাউকে ডেকে পাঠাবো।
So Lordship, so Lordship, only the difference is that in this matter, the appeal has been filed and that has been rejected.
Yes, yes. The petitioner, this writ petition, lays challenge to an order dated Yes. You're there, Mr. Chakraborty?
17.
Yes. Yeah, Abdul Jabbar. Jabbar Ahmed.
Yes. What is this matter, sir?
Well, it is, I have come against the order under section 73. My lord, adjudication order, I have come against the adjudication order, my lord. This order was passed in 15 July 2024. But the new account, my lord, the accountant could not get this order from the downloaded from this portal. Well, that was my fault on my part, my lord. But thereafter, my lord, this, I got the information only after they were trying, they tried to debit the credit ledger from, my lord, 1,46,000 they have already debited from my credit ledger, my lord. Well, only, my lord, there was a mistake in from filing the form GSTR 1 and 3B. My lord, there was a mismatch in GSTR 1 and 3B because in the GSTR 1 I have complied with, or
So
I have,
why have you not preferred appeal?
my lord, actually, my lord, I was not totally informed about this particular order.
Not
I got,
informed me?
my lord, only on the ground of, my lord, the accountant could not get this order from my portal. My lord, thereafter, the new accountant joined. My lord, I have stated in my para 7 of my application. My lord, kindly come to para 7. Well, when they started debiting my credit ledger, only on that particular time I was informed. Then that by to my
It must have been on the portal.
my post report, yes, my lord, it has been given in the portal, my lord. But this accountant, my lord, he has, without informing anything, my lord, he has left the company. My lord, thereafter the new accountant joined, my lord, he has given me all these details. My lord, I am ready to comply with any of the directions, my lord, as you love.
When was the order passed?
My lord, 15 July 2024, my lord, at page 16.
Let him pay some costs, he'll prefer appeal. The petitioner.
My lord, I am Robert. Here, my lord, last occasion, my lord, your lordship was pleased and recorded that there natural justice violation both in appeal and adjudication. Learned friend, my lord, prayed.
Take it up on Monday, by Monday.
Mr. Chakravarti, learned advocate, appearing for the respondent as GST authorities, seeks some more.
Same meeting. My lord, may I hand over the CAN applications?
At the time of rising.
Which one? Somebody else. My learned senior friend is appearing for the petitioner, Miller, but the matter was mentioned by the department, Miller, and my lord was pleased to fix it today, Miller. Miller, in the last order, lordships had directed me to file in a sealed cover. The reason as to why we are wanting to inspect and verify, Miller. Safe house, I'm fumbling for that word because it's a new word for me.
My lord, there's no direction to submit in a sealed cover. My lord, that the submission was made. My lord did not record that. And
Lordship, paragraph 7, my lord's order is there. My lord so deems fit and proper that my lord intended me to file it in a sealed cover. No. I shall do that, and if it does not, my lord, paragraph 7, lordship, if my lord reads
very well, my lord, may I only humbly submit this note regarding the sealed cover procedure. My lord, the judgment of the Supreme Court will kindly consider that before my learned friend invites my lord to resort.
Then my lord will not open the seal cover. I can join issues with my learned senior friend on that also. But as far as this case is concerned, I will first try to satisfy your lord, my lord, that as far as the proceeding of 263 is concerned, I am well within my right to inspect that particular the jewelries which are lying in that safe in the presence of my learned senior friend's client. If I am unable to satisfy your lordship as far as that aspect
No,
is concerned.
the question is not whether you can inspect or not. That's right. That power you have. The question is whether you would do it without informing him. The reasons for your such inspection. That is the only question.
I have prepared myself, though I am not very well versed with this branch of law. But my lord, I have burned my midnight oil and to the satisfaction of my lord. And of course, I will try to, my lord, because there is a judgment of the Honorable Supreme Court of 2016, which says that as far as the notice is concerned, when I initiate proceeding under section 263, I may not give a very illustrious reasons as to what I'm going to do on the same footing as if my lord will kindly appreciate my argument is only on this line. Supposingly, a authority is doing review. There are two issues on which I can review. One is if there's a loss of revenue and if something has not been looked into. Those are the 2 points. But my lord, taking a third view, as far as my understanding is concerned, my submission is. Now, my lord, I am reviewing a particular order. While reviewing that particular order, if I want to look into the materials which form parts of the record, which 263 specifically says. Now, what forms part of the record? Nobody can stop me from verifying the records, which allowed the learned, the assessing officer to come to a logical conclusion as to why he should come to that particular finding. The order, which I am reviewing. Now, my lord, my review, when I am reviewing that order, if I find that there is cogent reason to go and inspect the records or whatever forms part of the record, I am well within my right. Now, my lord, the second aspect of 263 comes that I have to put him on notice while making that inspection. That I have done. Now, my lord, my understanding is that 263 has not been challenged.
What has been challenged is the subsequent notice where we want to inspect the jewelries and others which are in a
not
safe.
informed him about the reason.
Well, we have not informed him about the reasons initially, and in that particular initially in 263 we have not informed. Now, Millard, as far as the judgment of 2016-11 SCC 748 is concerned, Millard, it specifically says, according to my understanding, that you need not illustrate in a threadbare manner or in a specific manner as to what you are going to do while doing the review of
context of this kind of inspection where it was kept in safe custody.
No, Millard, not that, but it is on 263, Millard, as far as notice is concerned. Because
No,
what I have
here-
done is
here this inspection is alleged to be conducted in furtherance of a 263 proceeding.
Lordship.
But once an inspection is to be carried out in terms of the rules, rules say that you will carry it out only for the purposes which are beneficial for the purposes of the act, is the expression used.
About it.
Now, if
Purposes,
this is the expression used, then what is beneficial for the purposes of the act cannot be decided prima facie by the authorities in the closed mind of the authorities themselves, because that may become arbitrary at one point of time. I think it is beneficial, so therefore I will do it without disclosing why I think it is beneficial. This
Millard, I get it, Millard. Millard, let us then, Millard, take 263. Lordship, Millard, we have it. Because my reading, maybe Millard, because Millard, I am taking inspiration from, while reading this section 263, Lordship, I am taking my inspiration from the Criminal Procedure Code as well as the Civil Procedure Code as to what happens in review and what is the extent of that review and what are the things which an officer who is assessing, to what extent that officer can go. Now, Millard, may I read, Millard?
Yes.
Section 263, Millard. The Principal Commissioner, Millard, I am not reading those lines. Then, Millard, may call for and examine the records of any proceeding under this act, and if he considers that any order passed therein by the assessing officer is erroneous insofar as it is prejudicial to the interest of the revenue, he may, after giving the assessee an opportunity of being heard and after making or causing to be made such inquiry as he deems necessary, pass such order thereon as the circumstances of the case may justify, including so and so. Now, Millard, so Millard, first of all, Millard, I am pausing on the second line, may call for and examine the records. Now, Millard, what I understand of any proceeding under the Act, and if he considers that any order passed therein by assessing, now, Millard, he is sitting in review over an order. Now, order has not come from, it is based on the finding of the officer on certain basic records. Now, my lord, then, my lord, last but two lines of that particular paragraph itself, he may, after giving the SSC opportunity of being heard and after making or causing to be made such inquiry as he may deem necessary, pass such. Now, what inquiry I am supposed to make? For inquiry, I have to first see the records as to whatever assessment the assessing officer has done from the records. He has come to a finding. I am reviewing that finding. For example, Millard, I don't know how far I am correct because I am still Millard, but I am still learning Millard. Now, Millard, supposingly there is a criminal proceeding. I am in review. Or there is a civil proceeding, I am reviewing. Error apparent on the face of the record. If there is error apparent on the face of the record, in review, I can go into it. Now, what are the records? Is it said that the jewelry which is put in the safe locker is not forming part of the record? It cannot be inspected. My understanding of the statute, Millard, with deepest of respect, Millard, is slightly different and there's a departure. Now, Millard, subsequently, he can give notice. Now, Millard, we have given notice to him, to my learned senior friend's client, saying that we are going to inspect that. Now, Millard, when we inspect that, we can come to a conclusion as to whether the understanding of the subject of the assessing officer was true, correct, and proper or not. Otherwise, I have to go within the four corners. My lord will kindly say this is not the contempt proceeding where I have to go within the four corners of a judgment while implementing it. We are not an executing court. We are a reviewing authority. So, my lord, one cannot say that in review, I cannot go and take inspection of the records. When this particular jewelry, bullion, everything is forming part of the record and therefore it has been kept in safe. Now, my lord, the question of 260. Huh? If I'm wrong, I apologize, my lord. Now, my lord, as far as 263 is concerned, my lord, what my understanding is, my lord, kindly sees the prayers of the petition. My lord, will kindly bear with me, my lord. It is at page 41, my lord. My lord, will kindly see prayer A. My lord, they are challenging impugned notices, third line or fourth line of the prayer A. They are challenging, my lord, the impugned notices, communications dated October 24, 2025, October 29, and 7. My lord, as far as 263 notice is concerned, they are not challenging. They are not saying that it is bad. They are saying in on all other words that an appeal has been preferred. But here they are challenging my notice where I have said that please be present on a particular day. That also on the third occasion. Initially, when we said, they shied away and they said that they are not. There was some medical emergency or medical problems. Then second time, then third time they challenged. Now, my lord, in my respective submission, the only point which we are trying to agitate for your lordships, that we have given them a notice while we'll take inspection. That inspection. Now, after taking that inspection, I can come to a finding, even if qualifying my finding, the two which has been held in 2000 Supreme Court lordship. Now, lordship will kindly see what it is said. He may, after giving the SSC an opportunity of being heard and after making or causing as be made such inquiry as he deems necessary. Now, my lord, I am here at the stage of inspection of record, which does not say that what I will do during my review proceeding, I should specify it. Then, my lord, my adjudication which I will make, I have to foresee that adjudication, crystalline it into salient features and give it into that notice under section 263. There cannot be a flow chart by a quasi-judicial authority or quasi-adjudicating authority as to where his set of mind will go. Because whenever he reads an order, he has to refer to the records. He may deem it fit and proper. Because from where I will learn. Otherwise, I will have to toe the line of adjudication and ascertainment and assessment of the record as done by the assessing officer. Then the whole concept of reviews, laws which says that there is error apparent on the face of the record. So, my lord, in all other words, my lord, I could not find, and now, my lord, adjudication is still to take place. First, I will inspect the record, which includes this particular aspect, and then I will come to a conclusion as to whether I will assess it or because all the judgment says that nobody says that I cannot review. It says that review should be on this cogent reasoning. If I try to supply my understanding and set aside that order in review, that cannot be done. I have to see whether he has assessed everything or not. If my lord again allows me, if just flow my lord, again, my lord, for my understanding, my lord, again reading, my lord, the section. Commissioner may call for and examine the record of any proceeding under this act, and if he considers that any order passed therein by the assessing officer or transfer pricing officer, as the case may be, is erroneous. Now, my lord, how I will come to know whether it is erroneous or not? Insofar as it is prejudicial to the interest of the revenue, he may, after giving the, now, my lord, whether it is erroneous or not, now, my lord, Supreme Court 2000 says that if he has not applied his mind to the matters of record, and if the revenue is being lost. They are the two parameters. If my lord takes 2000, judgment, my lord, I was reading, and I am with my understanding. So, my lord, as far as the other parameter is concerned, whereas taken into consideration the other aspects of the record, while adjudication, that I need to understand only by inspection of records. Now, my lord, what prejudice will he suffer? The cogent reasoning is this: if, my lord, if I am not putting him to notice, now, my lord, I, in a plaint, when it is given, now, my lord, issues are to be framed by the adjudicating authorities. And when issues are framed, then only the adjudication is to be made, and then evidence comes. Now, my lord will kindly remember that BP Pachal's case, 2003 1 SCC. What happened in criminal? Why I am giving this? Because I am more akin to the criminal and civil side. Now, my lord, the appellate court said that whatever evidence comes, kindly take it on record. Because the appellate authority at any point of time may think that that particular document should have been on record by way of exhibit in order to avoid remand. So the core of any adjudication in review, revision, or appeal is based on record. It's an integral part of adjudication. If I am not allowed to see the record, how will I assess, Lordship, in my respectful submission, that whether the analogy applied by the assessing officer and the reasoning which is based on certain records is correct, true, or not? Now, my lord, and second is, my lord, again, at the cost of repetition, what, my lord, prejudice my lord and senior friend's client is going to suffer if it is going to be done in its presence.
How is it prejudicial to the revenue if the information is given as to why the reasons are informed, that why inspection is to be carried out?
My lord, if reasons are, my lord, reasons, my lord, in my respectful submission, my lord, very humbly, my lord, if there is nothing provided in the rules and in the act that I have to give.
Rules say that there has to be reasons. Now, it is silent on as to whether it has to be made over to the SSC or not, has to be informed to the person whose articles have been seized or not. It doesn't say so that specifically, but it doesn't prohibit you either.
My lord, it doesn't prohibit me. My lord,
now, in case where the documents are in the custody of the revenue authorities and the documents have been seized by the revenue authorities from the custody of a person who is at the moment owner of the goods, he is put on notice only for that purpose, so that he is present at the time of inspection, but he is not made aware of the reasons wherefore the inspection is to be conducted.
My lord,
what is the basis of this?
My lord,
because there has to be reasons.
My lord,
now, if there are reasons, non-disclosure thereof, will it not be an arbitrary exercise of power in some cases? Because I will always say that there are reasons.
My lord, may I place one judgment before my lord? And then, my lord, I will try to very humbly answer to my lord's questions. This, my lord, reported in 2016-11 Supreme Court cases 748. If my lord allow, there's one paragraph which I am trying to place before your lordship. There's paragraph 12 at page 755. May I read, my lord? 755, my lord, paragraph 12. May I? It may be that in a given case and in most cases, it is so done, a notice proposing the revisional exercise is given to the SSC, indicating therein broadly or even specifically the grounds on which the exercise is felt necessary. But there is nothing in section 263 to raise the said notice to a status of a mandatory show cause notice affecting the initiation of exercise in the absence thereof, or to require CIT to confine himself to the terms of the notice and foreclosing consideration of any other issue or question of fact. This is not the purport of section 263. Of course, there can be no dispute that while the CIT is free to exercise his jurisdiction on consideration of all relevant facts, a full opportunity to controvert the same and to explain the circumstances surrounding such facts as may be considered relevant by the SSC must be afforded to him by CIT prior to finalization of the decision. Now, my lord, coming to my lord's, my lord, very humbly answer. Here, what is the stage? I gave a notice under section 263 to start my review. While reviewing the order, I came to an understanding that I need to inspect the records. It is a thought process which has developed in my mind while I was going through the order under review. Because certain documents, certain things have been relied upon in that order. So, my lord, if I don't get access to that, I am unable to form my opinion whether I can review that order or I should not, whether there is any error within the parameters of erroneous or whether there is any loss of revenue cost or not. Now, my lord, if I am not allowed to do that, of course, I will, once I do inspect the records, then I will come to a reasoning that these are the questions. Then those questions I will frame to them for them to show cause. But here, my lord, without inspecting, I am also in the dark. It may be that everything is correct. Then I will simply decide the review, maybe not even touching that order under review. But my lord, in order to exercise review, then I have to, one cannot stop me from inspecting the record, because then I will not be in a position to adjudicate the matter within the parameters of 263. How I will find that there is error, or how I will find that there is any loss of revenue or not. And what this judgment says, that once I need not give all the details categorically, point-wise, or the salient features of my understanding or my adjudication at the stage of finding by inspection of the records, then I will have to put them on notice that this things we have come to. So under those circumstances, but what they are doing, they are not challenging 263, but all actions taken in a view to come to a finding which we are doing, they are trying to stop by coming to this honorable court. Now, my lord, why? How, my lord? If my lord, it is about prejudice, or my lord, it is about audio alterum partum, or they being taken by surprise is concerned. It would have been if I take inspection, I frame them, and I set aside the order. I have not done it yet, and I am not campaigning for that aspect. But then, my lord, if I do it, yes, I'm out of this honorable court, my lord. But as far as this stage is concerned, my lord, this is in a nascent stage, a premature application where more apprehension is there. And then a question comes to me, my lord. There should be a level playing field for both. Appeal is done, my lord, challenge it. My lord, that they have challenged that order in appeal, my lord, which is under review. That I'm not going to that aspect because my lord knows it, my lord, because my learned senior friend has argued it. I am just trying to impress very humbly before my lord that this is it's a nascent stage where, my lord, they are apprehending, and my lord, if it is a level playing field, an honorable writ court has to say, see that there is a level playing field. No prejudice is caused at the behest of the government, which is strengthened by the act or the statutory provision. So, my lord, here there is a total level playing field because, my lord, if I go and inspect, what prejudice is going to be caused to them? And that is upon notice. It's not that I've gone, I've broken open the lock and I've inspected it and then I've come back. So, my lord, now I am asking a question to myself, while I am within my right to inspect the record in order to come to an assessment and then after that review the order. I have done it, and that as far as categorical mentioning in a flow chart as to what I'm going to do while adjudicating is not required.
That's not required. That's not required.
My lord, I apologize. फिर भी हम देंगे नोटिस, हमको क्या देंगे? No, my lord, I apologize, because my lord, very youthful exuberance, they have tutored me the entire yesterday, my lord. Therefore, my lord, they are putting in words, my lord. I'm just breaking the flow, my lord. My lord will not take me amiss. Now, my lord, as far as, now, my lord, one more point, my lord. As far as when we are trying to inspect this jewelry, my lord, they have come up before this one. If I inspect other things which are also form part of the record, will they stand in the way? Can they stand in the way? And, my lord, as far as my lord is referring to rules are concerned, my lord, rules are always assisting the act. Now, statute in its wisdom does not bar me from exercising my rights to inspect the records of a proceeding, may call for and examine the records of any proceeding under this act. It's a very, very wide term. To come to what? Whether it is erroneous or not. So, the statute in its wisdom gives me that power. And, Millard, as far as this 2016 decision is concerned, Millard, it has categorically said that in 263 notice, I need not give a flow chart of what I'm going to do, why I'm going to do, and where I'm going to do. And, Millard, it is also not cogent enough that I will foresee my adjudicate, because that is an alarm of being prejudiced. If today I make up my mind before reading the order under review that what I'm going to do, which documents I'm going to inspect, which jewelries I'm not going to inspect, that means I have already premeditated myself to come to a conclusion, whether on this side or on that side. So, my lord, it is cogent that when a reviewing officer reads the order, comes to an understanding that where things may have got wrong, and then he wants to reinspect a particular record in order to be sanguine. Because this is also what the Honorable Supreme Court says, that if everything has been applied, all the documents, evidence, everything, whatever has been applied in the order and has been taken into consideration in a correct manner, then you cannot do anything under 263. So if I find after inspection that everything was done and in a correct manner, then why will I put them to that altar? But, my lord, what they are doing is, my lord, they are stopping me at the nascent stage. They are not allowing me a level playing field. What prejudice will be caused? I go and inspect in their presence, and whatever is the outcome will be there. And then I will adjudicate, and they have all the chance. Then I may put questions to them that this is what we have come. And if then they give a right answer to that. So, well, this is my humble submission, Miller.
Yes, Mr. Ketan. Why should I not open the sealed cover?
But on that part, kindly have the judgment note of Supreme Court. But it is what the Supreme Court has been pleased to hold me that this is a very restrictive process. See, photo compilation. I just wanted Supreme. My page number is not matched. No, there are other decisions. Kindly ignore those. I do not have it. I'll be referring to the page numbers of the reports. Look, this decision, look, I'll give my friend a copy. Look, it is Madhyam Broadcasting Limited versus Union of India, 2023, 13 SCC 401. 401. Look, in this compilation, look, it starts at page 152. And look, I will be referring to because the page numbers of the reports are also, look, my lord will find it are printed. So if I can look the kindly, if I may draw attention to look, page 456 of the reports, paragraph 66, 67, and 69 first email. But kindly have a look at the page 456 of the reports note, paragraph 66.
Page 456.
Lordship, paragraph 66. 66. May I please? MHA disclosed the materials forming the. Well, may I kindly have this one. It is better. The compilation is not unnecessarily too voluminous. But kindly the repetitive judgments not on the same principle are not required. This is a long enough judgment note by itself. You may take that compilation back. I've given a copy to my learned friend also. Because there are two page numbers and then it'll reach here. So kindly have note page 456, paragraph 66.
Paragraph 66.
Yes, but if I may first refer to them.
Yes.
MHA, that Ministry of Home Affairs, disclosed the material forming the opinion for denying of security clearance solely to the High Court. The High Court, instead of deciding if any other less restrictive but equally effective means could have been employed, straightaway received the material in a sealed cover without any application of mine. It is now an established principle of natural justice that relevant material must be disclosed to the affected party. This rule ensures that the affected party is able to effectively exercise their right to appeal. When the state government claims non-disclosure on the ground of public interest under Section 124 of the Evidence Act, the material is removed from the trial itself. As opposed to this method, when the relevant material is disclosed in a sealed cover, there are two injuries that are perpetuated. First, the documents are not available to the affected party. Second, the documents are relied upon by the opposite party, which is most often the state, in the course of the arguments, and the court arrives at a finding by relying on the material. In such a case, the affected party does not have any recourse to legal remedies because it would be unable to disprove any inferences from the material before the adjudicating authority. This paragraph 16. This form of adjudication perpetuates a culture of secrecy and opaqueness and places the judgment beyond the reach of challenge. The affected party would be unable to contradict errors, identify omissions, challenge the credibility of informants, or refute false allegations. The right to seek judicial review, which has now been read into Articles 14 and 21, is restricted. A corresponding effect of the sealed cover procedures and non-reasoned order. Then we'll kindly take paragraph 69. But at page 458. Upon a perusal of the material in sealed cover, the single judge of the High Court observed that the files submitted by Ministry of Home Affairs indicate that the Committee of Officers took note of the inputs provided by intelligence agencies and found that the inputs are of a serious nature and fall under the security rating parameters. Single judge observed that in those circumstances, the Committee of Officers will advise not to renew the license. The single judge does not provide any clarity on the nature of the inputs that were of a serious nature. Additionally, there is no mention of the security rating parameters that have been relied on. A non-reasoned order perpetuates the non-application of judicial mind in assessing the veracity of the inputs. The nexus of the reasons in the order cannot be adjudicated upon if the reasons are not disclosed. So this is one part, and then kindly have note. There are kindly take note page 487, paragraph 140. So this is under the heading. The heading is at page 483. It is the jurisprudence on public interest immunity claim. The Supreme Court considered as to which is less restrictive, public interest immunity claim under Section 124 of the Evidence Act, or a sealed cover procedure. So first, the Supreme Court summarized the position with regard to this public interest immunity claim in paragraph 140 and then the various subparagraphs. This is the procedure which is provided. I just wanted to draw attention to paragraph 140.4, But this part of the procedure, when a claim of public interest immunity is made, the court must, on a perusal of the affidavit filed, that the minister or the head of the department decide if the disclosure would be injurious to public interest. So, that is the part of that procedure. Then, kindly take note at page 498. For the heading at page 498, after paragraph 163, is public interest immunity or sealed cover, the less restrictive means. So this was, I'll place the material portions note. Kindly have paragraph 181, at page 503. But I kindly take 180 first. Then the claimant would be jumping into a pit of fire with their eyes closed, even if they consent to a sealed cover procedure. As Lord Kerr remarked in Al-Rabi, the claim that closed material procedure would provide a fairer outcome is premised on the assumption that the adjudicator is impartial. However, beyond this assumption, it must be recognized that the court could be misled by the material that is not subject to inspection and examination. This would lead to a situation where the court renders an unfair judgment, and such an unfair decision would not be amenable to both judicial review and public criticism on merits. While it cannot be denied that allowing a public interest immunity claim may cause some degree of injury to the procedural guarantees of the claimant and the defendant, a sealed cover procedure will not ensure a fairer proceeding. The purpose of public interest immunity proceedings would become redundant. If the defendant is provided the option of requesting a closed material procedure after the conclusion of the public interest immunity proceedings, which the defendant makes, is allowed. Rather, we are of the opinion that the effect of public interest immunity proceedings of removing the evidence completely from the proceedings would persuade the state in making restrictive claims of public interest immunity. Further, as Lord Tyson remarked, the procedure would be inherently disadvantageous to the claimant because they are unaware of contents of the document. Then kindly see paragraph 183. The courts could adopt the course of action of redacting the confidential portions of the document and providing a summary of the contents of the documents instead of opting for the sealed cover procedure to fairly exclude the document from the proceedings on a successful public interest immunity claim. Both the parties can then only be permitted to refer to the redacted version of the document or the summary in the proceeding. In view of the above discussion, we are of the opinion that public interest immunity proceeding is a less restrictive means to deal with non-disclosure on the ground of public interest and confidentiality. This leaves the final issue to be answered. If public interest immunity is less restrictive means, then whether the procedure of sealed cover can be used at all, and if so, in what circumstances would it be permissible for the court to exercise its power to secure evidence in a sealed cover. While it would be beyond the scope of this judgment to lay down the possible situations when the sealed cover procedure can be used, it is sufficient to state that if the purpose could be realized effectively by public interest immunity proceedings or any other less restrictive means, then the sealed cover procedure should not be adopted. The court should undertake an analysis of the possible procedural modalities that could be used to realize the purpose, and the means that are less restrictive of the procedural guarantees must be adopted. This closed sealed cover procedure, the court is pleased to observe that should not be
lightly resorted to.
Because it deprives me, at least one party of knowing what is there. Now, in an income tax procedure, can you also have paragraph 195.2.7, at page 508. The courts assess the validity of public interest immunity claims which address the same harms as the sealed cover procedure based on the structural proportionality standard. The power of courts to secure material and seal cover when distinguished with the scope of assessment of public interest immunity claims is rather unguided and ad hoc. The standard of review that is used by the courts in public interest immunity claims and the lack of such a standard in seal cover proceedings to protect procedural safeguards indicates that the public interest immunity claims constitute less restrictive means. Additionally, while public interest immunity claims conceivably impact the principles of natural justice, the seal cover proceedings infringe the principles of natural justice and open justice. Now, in fact, for this public interest immunity claim, the court has been pleased to observe that the procedure should be to appoint an amicus curiae who will see the document and advise then it is excluded from the proceeding altogether. Nobody, the court, neither party will see because the state is claiming that immunity. So therefore the court and the parties do not see it is excluded from the proceeding altogether. That is the public interest immunity. So therefore this is what the court has been pleased to observe. Now in an income tax, under the Income Tax Act, the element of surprise is at the time of search and seizure. That is done without informing me. They record the satisfaction and they suddenly come and they do their statutory duties. But after that stage, that is they can come on a survey without informing. They can do that, but this element of surprise, when I have already been assessed. Now, there are other aspects which I will address, but not the inspection. If I know the purpose, I can go adequately prepared. Then I will go because the question of chain of custody. My learned friend said, there's a what is the prejudice? Now it was the articles were collected in a particular manner. There are so many people who have witnessed it. It is kept in a particular way, in a particular place. Now that chain of custody is sought to be disturbed. The rule says it must be for any of the purposes of the act. Now that purpose of the act is not being spelled out. The question is, if the inspection is to be made.
Mr. Khetan, can you please elaborate on this to disturb the chain of the custody?
Yes, because kindly have a look at that rule copy which I had handed up on the last occasion.
Yes.
This rule 112 and kindly see sub rule 10. That page, the handwritten page 6. The authorized officer, that the authorized officer who is conducting the search shall place or cause to be placed the bullion, jewelry, and other valuable articles and things seized during the search in a package or packages, which shall be listed with the details of the bullion, jewelry, and other valuable articles and things placed therein. Every such package shall bear an identification mark and the seal of the authorized officer or any other income tax authority not below the rank of the income tax officer and the occupant of the building, place, vessel, vehicle, or aircraft, including the person in charge of such vessel, vehicle, or aircraft search, or any other person in his behalf shall also be permitted to place his seal on them. A copy of the list prepared shall be delivered to such occupant or person. A copy shall be forwarded to the Chief Commissioner or Commissioner, and where the authorization has been issued by any officer other than the Chief Commissioner or Commissioner, also to that officer. Therefore, it preserves the details of the location where it is seized, who were present there, the person in charge of that place also puts his signature, the seal, and it is to be preserved in a particular manner till there is a situation for any purpose of the act which requires this custody to be disturbed, because it was seized elsewhere. It was found somewhere in a locker. It was seized there. It was conveyed it must be packages, because the authorized officer's duty is that there's a list, there are seals. Now, once that is disturbed, then there can be situation we are not quite sure what might happen, because there are individual human beings involved. Now, it has come in a particular way, and there are other people who have said that part of it is theirs. So not, it is also a question of not their claims, that those claims were made before the assessing officer also. Not that the part of the, not the, because there's about 19.5 kilos of gold bar note, which not the petitioner's father-in-law not is in the jewelry business. And not it was his. He has filed an affidavit not and documents to say that there's a dispute between him and his son, and therefore it entrusted this to his daughter not who had kept him in lobby. So not there are other people, but the out of not the about what was found was some 14 odd crores, little more than that. The officer in course of the proceedings accepted that 1 crore 66 odd is explained. The rest, 12 crore 33, he has teaches annexed name. Therefore, there are other people who are also involved. Not I am responsible to them. Now, therefore, the law says, not in 13 rule, sub rule 13, not at page 7. Not of course 12 before that. Not the custodian. The 11 before that. Sorry, not page 7.
Yes.
The authorized officer may convey the books of account and other documents, if any, seized by him in the course of the search made by him, and the package or packages, if any, referred to in sub-rule 10 to the office of any income tax authority, not below the rank of income tax officer, and after referred to as a custodian. Any money seized in the search referred to above may also be deposited with the custodian. The custodian shall take such steps as he may be considered necessary for the safe custody of books of account and other documents and package or packages conveyed to him. Then note 13. Whenever any sealed package is required to be opened for any of the purposes of the Act, the authorized officer may, unless he is himself the custodian, requisition the same from the custodian, and on the receipt of the requisition, such package or packages as the case may be shall be delivered to him by the custodian. The authorized officer may break any seal and open such package in the presence of 2 respectable witnesses after giving a reasonable notice to the person from whose custody the contents were seized to be present. Such person shall be permitted to be present till all or any of the contents of the package are placed in a fresh package or packages and sealed in a manner specified in sub-rule 1 or delivered to such person or the custodian as the case may be. Therefore, these are not safeguards provided by the statute itself. Now, the aspect not is that the commissioner is going to not examine the articles. Not kindly have the notice note which was issued in this case note under section 263. Note the volume 3 note page 355 and if I may draw attention to note page 356. Yes, it starts with the show cause notice, and not the this is a notice of hearing, and then what the facts of the case are there in paragraphs 2 and 3 about the search and the assessment in paragraph 4. Then 5. The assessment record was called for examining the correctness of assessment order. It is gathered on perusal of assessment record that the certain transactions issues were not properly examined, verified by the AO during the course of assessment. So that examination has already happened at the hands of the commissioner. Now then he finds the order to be faulty. Can you see page 364? An elaborate notice is issued, not showing not that the commissioner has looked at everything. Not he's discussed not in the prior pages. My lord, you find not he's looked at the statements and all the entire record, and then not he says in paragraph 17, in the assessment order passed for the assessment year 23-24, AO has erroneously accepted the additional income of rupees 13.5 crore offered by you in your hands on account of above said allegation of undisclosed professional receipt of firm DJ Shah and Company on account of undisclosed debtors, which should have been assessed in the hands of the firm DJ Shah and Company as per discussion under para 9 above. The AO further, while framing the assessment order, has wrongly considered the jewelry found and seized in your case as the application of the said undisclosed professional receipt, which makes the assessment order erroneous, as the said undisclosed professional receipt pertains to the firm DJ Shah and Company and not you. It is evident from the above that the professional receipt of 12 crore odd on account of debtors which remained undisclosed unaccounted was must be required to be considered in the hands of the firm DJ Shah and Company. However, the same has been considered in your hands, who is the partner of the firm, in your assessment order passed for assessment at 23-24, wherein it was stated that the jewelry and bullion found at your premises were sourced from the above stated undisclosed professional income. In view of the above facts and circumstances, the assessment order in the instant case becomes erroneous, as the undisclosed professional income of the firm DJ Shah and Company was assessed wrongly in the hands of its partner, Sri Miraj D. Shah, for assessment at 23-24, in whose case gold, jewelry and bullions were seized, which was stated to have been sourced from the application of the above discussed undisclosed unaccounted professional income on account of debtors. Further, the assessment order is prejudicial to the interest of the revenue, as certain income which ought to have been taxed in the hands of the firm was taxed in the hands of the partner of the firm, and corresponding benefit was given to the partner by accepting the source of the assets in the form of jewelry and bullion found and seized from his premises as the application of such undisclosed professional income of the firm. Further, the source of such assets in the form of jewelry and bullion was not verified, inquired during the assessment proceeding, and thus the same remained unexplained. Then paragraph 20. In the instant case, the assessment order was passed without inquiring, verifying the issue of the source of asset in the form of jewelry and bullion pertaining to the assessee as discussed above, which makes the assessment order erroneous insofar as it is prejudicial to the interest of the revenue within the meaning of section 263 of the Income Tax Act. Therefore, the allegation was that this money should have been taxed in the hands of the firm and not in the personal hands, and the officer has made the assessment on the basis that this money was used to get these jewelry and assets. That is not the case. Then where did the money come from to get these assets? That has not been looked into. That is how, that's what the income tax assessment is concerned with. Therefore, and I have filed my reply to this. The reply was filed on 17th of June 2025. Now, this 24th October, the inspection is not going to be done by the commissioner. Some departmental officer will do the inspection. Now, we'll kindly have a look at the provisions of section 263. My learned friend used the word review several times. It's not a review situation. Revision. It's a revision. And kindly have a look. I'm sorry, my time ran out. So the 260, the principal chief commissioner or chief commissioner or principal commissioner or commissioner may call for and examine the record. So that may call for and examine the record of any proceeding under this act. And if he considers that any order passed therein by the assessing officer, the transfer pricing officer, as the case may be, is erroneous insofar as it is prejudicial to the interest of the revenue, he may, after giving the assessee an opportunity of being heard, and after making or causing to be made such inquiry as he deems necessary, pass such order thereon as the circumstances of the case justify, including. Therefore, the record is the record that he calls for and examines. Thereafter, he gives me an opportunity, and then he can make such further other inquiries. So, therefore, that process has already been carried out by the commissioner.
Mr. Trivedi's submission is that those will also come within the definition of the expression records.
Part of the assessment record.
But the way it is, there's no question of calling for and examining the seized articles. But the reason is
according to him, it will come under the expression to cause to be made
part of the
further
assessment
inquiry,
record.
such
It is a
other.
part of the assessment.
that comes at a later stage. The inquiry comes, further inquiry comes at a later stage. The first is calling for and examining the record. Now, the seized articles, they were at the time of the seizure, the department had called for registered valuers. The registered valuers have detailed the items. They mentioned what is the grammage.
No, but in this writ petition, the challenge is not to the inspection per se. The challenge is to conduct the inspection without informing you about the reasons therefore.
Yes, because since the Act, the rule itself provides for not the unsealing if so required for the purpose of that. So I'm on the purposes of the act. My concern is, as I submitted, I ought not to be taken by surprise here, because if the inspection is for purpose A, I will go adequately prepared. If it's for purpose B, they must be for the purposes of the act.
What is so confidential, Mr. Trivedi, in this that cannot
My
be?
lord, much ado about nothing. Lordship will kindly not, if I can take that, my lord will not open the seal cover. What I am trying to submit very humbly, it forms part of the assessment record. Now, my lord, my learned senior friend is trying to put the cart before the horse. What has happened in this revision?
We'll have to assemble tomorrow then again with this, because 2 p.m. we have another matter fixed. This cannot spill over.
My lord, my learned senior friend may conclude. I think so. My learned senior friend has not concluded yet. So, my lord, then my lord will kindly let spill over tomorrow. कब होगा कल
लिखे नहीं You convince Mr. Khetan, he's there. If you can finish in 10 minutes, I'll take up your minute. হ্যাঁ এটা ফেরত দিয়ে দিন আমি রেকর্ড করে নিয়েছি ফেরত আর রাখার কোনো মানেই নেই খুলিও নি ওটা দেওয়ার সময় তাহলে খুলে দেবেন, এরকম আমাকে দিয়ে দিলে তো কোনো লাভ নেই। এটা তো আপনার কাজের মধ্যে পড়ে। আপনি যেরকম বললেন আমার ওটা কাজের মধ্যে নয়, এটা তো পড়ে। নিয়ে নিন।
My lord, Mr. Salve will join in 5 minutes. He's getting some problem in login. He'll log in 5 minutes.
Would your lordship kindly, it will take about 5 minutes. He just messaged me. So sorry.
Your last million is,
Lord, I appear for the SBI Lord led by one ASG. First of all, your lordship desire what Lord ASG will submit on Thursday. And Lord, I have been by the customs department.
Customs is party.
Union of India, at least, they're not separately a party.
Customs is not a party, which is why I have been engaged. Probably customs want to be a party. Customs is good.
Union of India is there, so everything will be taken care of.
Customs is a nodal authority. CIC is a nodal authority. Customs is collecting them.
But they should have been pointed out at the very threshold.
We were not aware.
Union of India was there. From the very beginning, Union of India was there.
When we were made aware.
Union of India was there always from day one.
Yes, but I am appearing for the first time, but even India was built.
Because territorial jurisdiction point has been taken and that is being argued. It's been argued for quite some time now.
If I won't try to assist.
ASG is not here, Mr. Tiwari, he is not here.
ASG has not come. No.
No, I have not fixed. I have not yet passed any order. I have not passed any order fixing any matter. It's appearing today. No. It was to the contrary. He said that he'll not be there in the second half. He'll be there in the first.
Traveling for personal day. And we have first day after. That is okay. Try to get sick. It is better to start in the morning. So Sandhya's presence is not required. He is finishing today. In fact, he just wanted to show some two letters, he said. Rest of the submission he had made. So, and because he cited a new decision, I'll just have a deal.
Wait, please, my lord.
Yes.
I'm so sorry, my lord. I had a wrong link. I was struggling to join. Can your lordship hear me, my lord?
Yes, yes.
My lord, I was just finishing my submissions on the territorial jurisdiction point. Your lordship recalls I had read the Adani judgment.
Yes.
And the submission is, my lord, that the mistake which often is made, my lord, we call it the difference between cause of action and causation. A cause, you may be affected anywhere, but that's not the cause of action. As Supreme Court has explained, my lord, in the case which your lordship saw, the Adani case,
yes,
cause of action is the bundle of facts that you need to prove in order to succeed.
Yes.
And I will not repeat it, my lord. Your lordship saw last time. I took my lord through a number of pleadings, paragraphs. Because what has been argued before my lord is an unfair opportunity. And I, my lord, took the liberty of taking your lordships through passages upon passages in the judgment, in the pleadings. What does he need to prove? He needs to prove on so-and-so date, I wrote a letter from Kuwait to Delhi, Delhi to Kuwait, Kuwait to Delhi, Delhi to Kuwait. And in this exchanges between Delhi and Kuwait, his case is he was not given a fair opportunity. Now this order is issued in Delhi. Well, you can take a copy of the order and go to any part of the world. The order is issued in Delhi, and the order, according to him, does not give him the kind of details which the law obliges the order to give. That's the law in short form of the case. And in order to prove his case, what does he need to prove? He needs to prove those facts. And your lordship has seen where those facts lie. Now, my lord, I just wanted to quickly deal with the other two cases. One of them is, my lord, the judgment in Kusam ingots, which says nothing different. It's, my lord, in the compilation of cases, page 66, if your lordship has that. This is 2004.
Yes.
2004, volume 6, Supreme Court cases 254.
Yes.
Now, my lord, the facts are a little important. Please see the question of law, page 70. Whether the seat of parliament or the legislature of a state would be a relevant factor in determining territorial jurisdiction of a high court to entertain a petition. Under 226, the question involved arises out of a judgment. The appellant is a company registered in Mumbai, obtained a loan from Bhopal branch of State Bank of India. Notice of repayment of the loan purported to be issued under the SARFAESI. So, the notice was issued in Bhopal. And what the petitioner did is he challenged the SARFAESI Act and therefore said Delhi High Court had jurisdiction. That your lordship will find in para 5, 4 and 5. Para 6 says exactly what Adani says. Cause of action implies a right to sue. The material facts imperative for the suitor to allege and prove constitute the cause of action. So, my lord, this is not causation. It's not injury. It's the facts imperative for the suitor to allege and prove which constitutes cause of action. That's not very clear. Cause of action is not defined in a statute, judicially interpreted to mean every fact which would be necessary for the plaintiff to prove, if traversed, in order to support his right to a judgment of the court. Negatively put, it would mean everything which, if not proved, gives the defendant a right to judgment. Then, my lord, after setting out the provisions of Article 226, Para 12, my lord, the court in ONGC said that the question of the court's territorial jurisdiction will be arrived at on the basis of averments. That's correct, my lord. It's on a demurrer basis. Then, Para 14 is important, my lord. This court opined that mere service of notice would not give a rise to cause of action unless the service of notice was an integral part of the cause of action. Which means one of the facts, if you are challenging a notice, then a notice is issued from somewhere that may give you cause of action. Now, my lord, Para 22, Para 21, sorry, my mistake. A parliamentary legislation, when it receives the assent of the president and is published in the official gazette, unless specifically excluded, will apply to the entire territory of India. If passing of a legislation gives rise to a cause of action, a writ questioning the constitutionality can be filed in any high court of the country. If it is not so, it is not so done, because the cause of action will arise only when the provisions of the act or some of them are implemented, shall give rise to civil or evil consequences. A writ court, it is well settled, would not determine a constitutional question in a vacuum. The court must have territorial jurisdiction. An order passed on a writ questioning the constitutionality of a parliament action with the interim of final will have effect throughout the territory of India, subject to the applicability of the act. Please pause here, my lord. This directly addresses the problem your lordship has in this case. Once, my lord, this becomes law, if tomorrow the central government were to accept this recommendation and issue a final notification in terms thereof, that's when the injury will be caused. That becomes law. That's law all over India. Does it mean he can go and challenge it anywhere? Because it's uniformly applicable all over India. Wherever you import these goods, you'll have to pay this tax. And that is, my lord, answered in 3 steps. Para 23 says the office is irrelevant. Citers of the office of the respondents are the relevant. Respondents' questioning parliamentary act shall not be maintainable only because the seat of the Union of India is in Delhi. Learned counsel for the appellant in support of the argument would contain citers of framing the law would give jurisdiction. Then, my lord, cases are cited. Para 27. I'm sorry, my 26, my mistake. The view taken by this court in UP Rashtriya Chini Mill Adhikari that the citers of the issue of an order of notification of the government would come within the meaning of cases arising in clause amalgamation is not a correct view of the law for the reason that to the extent stated, the decision is overruled. In fact, a legislation it is tried to not confine to a statute enacted by Parliament or legislature, which would include delegated legislation and subordinate legislation, or an executive order made by the Union of India. In a case where the field is not covered by any statutory rule, executive instructions issued shall also come within the purview. Citers of the office of Parliament, legislature, or authorities empowered to make legislation would not by itself cause any cause of action. In other words, the framing of a statute, rule of an executive order, instruction would not confer jurisdiction. Where an order, however, is passed by a court or tribunal, or please mark the words, Malad, an executive authority, whether under the provisions of a statute, a part of cause of action arises in that place. So, my lord, where this order is passed is where the cause of action arises. That's Delhi. In a given case where the original authority is constituted in one place, appellate authority is another, writ would be maintainable in both places. In other words, an order of the appellate authority constitutes part of the cause of action, the writ would be maintainable, etc. And that is where, my lord, the court then also looks at Article 226(2) it deals with part of cause of action. And then, my lord, para 30. We must, however, remind ourselves, your lordship, that they mentioned forum convenience. This is the judgment which says, remind ourselves, even if a small part of cause of action arises within the territorial jurisdiction, the same by itself may not be considered to be a determinative factor compelling the High Court to decide the matter. So, my lord, this is the settled law. And what is the basis on which my learned friends assert jurisdiction, territorial jurisdiction? Your lordship will have to see the petition. But unfortunately,
The primary basis appears to be the pleadings made in paragraph 41.
yes, my lord. I was just turning it up. Your lordship is pleased to turn to the cause of action clause. The petitioner states that this honorable court has jurisdiction where the impugned order is implemented. My lord, I don't think your lordship has found this proposition anywhere. Secondly, my lord, and this is important, if your lordship sees on what basis is it urged that this order will be implemented? My lord, let's be very clear. This is a finding. This finding will be given to the union government in Delhi. My lord, where is this order going to be implemented? In Calcutta or in even West Bengal, anywhere in India? This is purely a finding. And he doesn't explain if your lordship in fact sees two more paras. I just wanted to very quickly show the grounds also. And I'm done, my lord, with this. First of all, my lord, he doesn't explain in his pleadings what he means, because that's obviously a boilerplate clause, as we call it, my lord. Please mark the next line. Your petitioner highlights that bona fide customers of MEG located in Calcutta procure your petitioner's exports via Haldia. Financial year, your petitioner's exports were purchased by Dhunseri, who's not happy to withdraw his case and go away, a customer. However, now please mark this, my lord, imposition of anti-dumping duties would require customers to pay more duty. Now, my lord, first of all, there is no duty today. A duty will be levied. He may find a customer. That customer may choose to import in Haldia. Well, these are not the facts he needs to prove his case to win. What does he need to prove his case to win? Well, not assuming all this is true, or assuming this fact is not true, his case on merit still holds. And that's why I just wanted to show, my lord, and your lordship doesn't have to read it at any length whatsoever. paragraph 39, just below para 39, and please just see the grounds. The very first ground says it all. This is what he has to prove to your lordship. That the final findings are liable to be quashed as they have been rendered in violation of Rule 60. And then he goes on. Of what, why? So, my lord, this is his cause of action. That the findings are in violation of Rule 16. This didn't happen in Delhi, anywhere except Delhi. So, my lord, my submission is on this principle. There can be no question of any territorial jurisdiction in any court other than Delhi High Court. And, my lord, secondly, and I'll just deal with it in one sentence, on an alternative remedy, is a complete appeal on facts and law. If the tribunal is not sitting, he will go to the Delhi High Court and get a direction issued for them to constitute a special bench. My lord, it's not that your lordship's board is so light and the tribunal's board is so heavy that one says we come to the High Court, because the High Court doesn't have much work to do and the tribunal has a lot of work to do. I mean, that would be a rather cheeky thing to say. So, my lord, I submit both on alternative remedy and this it fails. One last point, my lord, which I want to make, and this is a point of serious principle. A number of the allegations are made on documents which are redacted. And, my lord, that is simply not permissible. May I, my lord, develop this point in 5 minutes? If your lordship turns up Rule 7, this is the rule of confidentiality.
That NSD rules.
Yes, ma'am. Your lordship has the rule, my lord.
Page 135.
Yes. My lord, in this rule, if your lordship just reads it with me, this rule applies to the proceedings before the authority. It says, notwithstanding so and so, so and so, copies of application or any other information provided to the designated authority on a confidential basis by such party will not be disclosed. Now, my lord, this is not information, or rather, this is information which is given to the statutory authority. And the statutory authority decides how to deal with this information. Because if your lordship sees, this applies at the stage where party has given information, the designated authority is satisfied as to its confidentiality, and no such information disclosed to any other party. Now, my lord, today my learned friends have filed a judicial review proceeding, a petition under Article 226. This rule does not apply to pleadings in court. Pleadings in court follow one strict rule. And that rule is that you cannot run a case which is not known to the other party, except where you claim privilege. Or, my lord, if somebody has, your lordship has not so much experience, if somebody has to file a document, like in the testamentary jurisdiction, sometimes they file documents, wills, then you take leave of the court, you file the complete document, you move an application in court, you pray for confidentiality, you get an order of confidentiality. Today, my lord, one can't hand over papers randomly redacted. And I just show, my lord, one or two of these papers, just to show the nature of the redactions. Please turn up page 434. Rule 6 says confidential information. Please see the kind. Please refer to the authorities in Excel appendices and backed up ethylene cost submitted on 21st/4. And then the next 5 lines are gone. I can understand you. What you normally do is if there is a figure, you black the figure out. You don't remove the principal, you black the figure out. Look at the next paragraph, B. As per the trade notice, details of related party transactions or any inputs provided, whether the transaction is at arm's length price and comparable arm's length is available. Next 4 lines gone. During the course of desk verification, what happened during the course of desk verification? Blank. Well, this is playing fast and loose with the court, I'm sorry to say. And there is a interesting passage, my lord. In the English, we have followed the English law by and large in this in Radharan's case. And there are 2 paragraphs, my lord. I just want to show your lordship and I'm done. It's a judgment of the UK Supreme Court, my lord. It's a recent judgment. It's called Al-Rawi and the Security Service. If your lordship turns to paragraph 1.
Can I have a copy of that?
Mr. Jain, please organize to have copies given.
Yes.
It's very interesting. There is a procedure. We do not, in one sense, we do not formally have such a procedure. This is called closed material procedure. You not have that one? Para 1.
Yes.
The issue that arises on this appeal is whether the court has the power to order a closed material procedure as described in the preliminary issue that was tried by Silberje for whole or part of the trial of a civil claim for damages, and if so, in what circumstances it is appropriate to exercise the power. The preliminary issue was in these terms. Could it be lawful and proper for a court to order that a closed material procedure be adopted in a civil claim for damages? What's the closed material? Closed material procedure means a party which is permitted to comply with its obligations for disclosure of documents and rely on pleadings or written evidence or oral evidence without disclosing such material to the other party, if and to the extent the disclosure would be, please mark the word, contrary to public interest. And withheld material is called closed material. The disclosure of closed material is made to special advocates and where appropriate the court. And the court must ensure closed material not disclosed to other parties, etc., etc. So there is a full procedure. And my lord, here also, the principle on which it is, please see para 12. Second, trials are conducted on the basis of principles of natural justice. There are a number of strands of this. To this, a party has the right to know the case against him and the evidence on which it is based. He is entitled to have the opportunity to respond to such evidence and any submissions. The other side may not advance contentions or reduce evidence of which he is kept in ignorance. The Privy Council said in a civil case of Kana and government of Malaya If the right to be heard is a real thing which is worth anything, it must carry with it the right of the accused man to know the case which is made against him. Even so much evidence is being given, what statements have been made, and then be given a fair opportunity to correct or contradict. Another aspect of the principle of natural justice is that the party should be given an opportunity to call their own witnesses and to cross-examine the opposing witnesses. Then my lord, he and queen is given. And then comes the two competing interests, para 15. A striking example of the court has to balance the two competing interests. Cardinal and Rock, registered police informer brought an action against the police to recover payment for information. The defendants denied any contractual liability to make the payments or information assistance provided by the plaintiff that had led to arrest. The claim was struck out by the Court of Appeal on the ground that fair trial the issue would require the police to disclose in the court to investigate and adjudicate about sensitive information, which should, in the public interest, remain confidential to the police. Test is always public interest. My lord, your lordship will not disclose it or permit withholding of information which causes prejudice to a party or public interest. My lord, not like this. A person chooses to redact saying rule 7 of the rules give me permit to redact and therefore I am redacting. The authority has not given me this letter. Authority has not disclosed anything. Authority has disclosed what he has to. My learned friend wants to rely on what he wrote to the authority. He has to either get your lordship's leave, which he would have a right to contest, and your lordship would decide if some information has to be held back in larger public interest, not private interest. Yes, it is in public interest also to maintain a degree of confidentiality or commercial sensitive data. I don't say no. But my lord, who is it to decide? Not the petitioner for himself. And where do I get an opportunity to challenge this? So my lord, I submit this for all these reasons. Your lordship would, my lord, not entertain this petition, and the judgment which has been cited in Eastern India Edible Oil by learned single judge in 2004. If your lordship just sees that, I need to just deal with that and I'm done. Mr. Justice Bhaskar Bhattacharya's judgment.
Yes.
This was, my lord, a canalization case. If your lordship comes straight away to page 35F, the petitioners complain.
Page
35, madam.
35
Running page 35, madam.
of the
I don't.
petition.
No, my lord. I'm so sorry. My mistake. Compilation of cases given by the petitioner.
Mr. Salve, this judgment was separately handed up. It is not a part of a compilation.
Oh, I see.
India
Then, my
judgment.
lord, then may I, my lord, show it?
That you have prepared. Oh, that's right.
May I'll have to, my lord, show my lord para-wise because there is no unfortunate.
Yes, para-wise will do.
Yes. So, my lord, in para 2F.
Para 2F. Yes.
Yes. The petitioners complain that by virtue of the notifications issued by the Government of India, the STC alone is entitled to import duty-free vanaspati from Nepal. According to them, STC has no right to transfer such authority to the private individuals in lieu of money, thereby enabling those persons to import vanaspati to India at 30% lesser price than the one prevailing in the market. The petitioners further complain that the relevant notification issued by the Union of India having permitted the STC alone to import those duty-free goods, the Customs Authority illegally permitted those private agents of STC to get the benefit of free importation. The petitioner alleged both STC and customs are bound to follow the policy, hence the application for a direction to the authority to implement the policy decision. It is opposed by STC, 2 sets of affidavit. Now, in this context, this question came up. And the way the contention was in para 8, third line, Mr. Sengupta contends that the grievance of the petitioner is that the writ application is that the customs and are both states within the meaning, have both violated the law of the land, and the violation affected the fundamental right of the petitioner to have equality before law. The moment duty-free Vanaspati, illegally cleared by customs in favors of the so-called associate distributors of the STC, had entered the market of West Bengal, because those agents are favored with the self-same commodities. Not with great respect, but the learned judge didn't have the benefit of either the Kusumingat's judgment or the Adani judgment. Kusumingat's is there, I'm mistaken. Para 13, he notes Kusumingat's. And para 14, the learned judge says, if we apply the principle to the fact of the present case, as soon as customs illegally cleared the commodities in Bihar border of Nepal, though the illegality complaint is accomplished, such impropriety committed did not give rise to any cause of action for filing any writ petition in the favor of the petitioner. But so long as such act did not invade any of the rights of the petitioner, the moment those duty-free goods intruded into the zone of business of the petitioners, the intrusion gave rise to the evil consequence to the petitioner. Now, this with respect, is not the cause of action principle. Somewhere along the way, we have forgotten. What are the points he pleaded? The points he pleaded was that the STC is entering into contracts with petitioners in Delhi. The rest is all which happens as a consequence. I submit the learned judge does not appear to have had the benefit of the Adani judgment, because I've read this whole judgment, it is not cited. And I therefore submit on natural justice. A full appeal is available if there is any merit in this point. And I have, my lord, 3 therefore points to conclude. First of all, territorial jurisdiction. Your lordship has heard me at great length on that. Secondly, complete alternative remedy. Your lordship has heard me at one length. And thirdly, my lord, even otherwise, on alternative, as a facet of alternative remedy, your lordship will put into the scales the fact that here the statutory authority has invoked what are equivalent to what are called best judgment powers, because he kept back some information. Now he's saying, despite which you have to give me information, not give me information. I had, my lord, your lordship remembers, said that there is a difference in the language of the rules. All that Rule 16 requires is disclosure of essential facts. This is not, my lord, like a adjudicating authority saying, I made 5 submissions, you have to answer each 5. That's not what the rule requires. Rule 16 requires that the designated authority, before giving final findings, shall inform all interesting parties of all the essential facts under consideration. So it gives him, my lord, he's a statutory authority, he's deciding economic factors. He's not deciding an appeal by a person. So, my lord, as long as essential facts are disclosed, and now whether they are essential facts or not, the tribunal will have to really figure out as to which fact was disclosed, which fact. The approach which my learned friends bring to bear, saying, oh, he made some calculation which his order doesn't disclose, is not by itself something which will vitiate the order. So it's not one of those cases under 226 in any case where there is a complete alternative remedy that your lordship will take. That one is my submission. I'm so grateful for a very patient hearing.
Thank you.
Much obliged. May I be excused?
Yes, yes.
Union of India has completed their submission, then Mr. Day will complete the submission on behalf of the standard.
Why you conclude? You conclude today, don't hold on, because
I'll just make a call to Mr. Day.
One new judgment has been cited, two actually. And with the two factual arguments have been raised, which are not raised. So I only need to make the legal factual. I don't want to take on
Yes. This territorial jurisdiction, then alternative remedy, then merit. That is how I'll have to proceed. If one I am able to cross over, then only to the next, and then only to the next. It could have been there. We could have then completed one.
Told that 2009. So therefore, I was not verified. That's why I was not because I was told that.
No. On the last occasion, he had made it clear that he will not take more than 5 minutes. That was what
Because letters he wanted to show, but today we got both sides. He's used it well. But no, please. That is a case of not. I am watching the star. Well, I am a fan of. Whatever income tax matter is argued to the Supreme Court, has the opportunity to read the judges. We always do something new to the people. So, I have actually looked upon him as a star. It is a case of the fan versus this. At least now he recognizes me by me. That is not the star. That's a big thing for a fan.
But I'm so sorry. Even though Mr. Ray is online, but he's not picking up my phone. I think there's some network issue or something. Otherwise, he could have started at least today and maybe finished on the next day.
But this was known that Mr. Salve won't take long. Last year only he had clarified it won't take long because I was having a division bench. I was rising. He said if I can get 5 minutes, I'll wrap up. It has been there.
So, Lordship, if the union can start today and complete the next,
it would make sense because half of it, then half of them, then again half somebody else.
In that case, Lordship, I would say that Mr. Ray starts on the next day and we will finish.
Then we'll not be able to hear the union and it will again spill over. Because unnecessarily I don't want to drag it. I also want to get it off my shoulders.
We appreciate that.
Yes, because on the same point, we are coming back again and again.
We won't take more than 20, Mr. Ray won't take more than 20, 25 minutes.
We should have utilized these 20 minutes today.
I agree, absolutely not.
I was just beseeching if Mr. Sundaria can finish first.
On the same points, we are coming back again and again.
We won't take more than 20. Mr. Ray won't take more than 20.
I think your submissions are reverberating. What to do then?
Lordship, if it could be kept on Thursday, subject to what my internet senior.
Thursday, all three of you will be able to conclude.
But I do not know that there is a set of counsel for the union. Government respondents, I have no idea how they will proceed.
Because Mr. Tiwari, some submission has already been made by Mr.
So that thereafter will make some legally only on legal issues will not whether the court has figured whether will not alternate remedy will be a bar and these two things will not will make only will not regarding federal jurisdiction and alternative. Submission on these issues. Some news as well, but nothing.
Repetitive.
I might not express my not thought that she has next week first territorial already contract. Please, my lord, please that territorial.
Only then alternative and if alternative I found is not complete, only then merit, otherwise not.
So at this point, we must take to the territorial that as another alternative.
No, since I have heard, because in course of arguments, I was taken through the entirety of the petition, even for the purpose of territorial, because uh, that was how the matter proceeded with.
Alternative remedy because therefore natural justice came in because of that.
So, alternative remedy part to answer that violation of natural justice, so merits, and it was all intertwined there. Till territorial jurisdiction, we can always keep that off segregate. Territorial jurisdiction is one aspect. If that is considered one way or the other, then we have clarity on the issue. But then we are not completing. That is the problem. We can in Thursday when morning has to be in the morning.
We have no difficulty. Morning. No difficulty. Morning will do.
No.
At any time, my lord, any time.
Mr. Rai, how long would you take?
2 minutes, my lord. Only 5 minutes by the clock.
5 minutes.
5 minutes. Absolutely.
Not much less than 20 minutes for us.
Then Thursday. Then heard Mr. Salve, learned senior advocate, appearing for the respondent number 3.
Respondent number 3.
3. Respondent number 3. Full stop. Mr. Rai, learned senior advocate, appearing for the respondent number 4. Seek some time to make submissions. Full stop. List this matter once again on পরশুদিনের date দিয়ে দিই 18th December 18, 2025 for continuation of argument for submissions of Mr. Rai and Union of India. At 10:30 am. 10:30 am. We'll not take the entire first half, I presume. Please be short because I'll be accused of not running through the list prior to the vacation. Yes, yes, it is indeed interesting.
The injury part of it.
Yes.
Wants to dissociate the injury.
Yes, yes.
So that too, I don't think.
Lordship, just a small correction. Mr. Salve is for respondent 4 and Mr. Rai is for respondent 3.
ওটা চেঞ্জ করে দিন মিস্টার সালভে ফর রেসপন্ডেন্ট নাম্বার 4 মিস্টার রায় ফর রেসপন্ডেন্ট নাম্বার 3 করে দিন কারেক্ট করে দেবেন থ্যাংক ইউ So he wanted it to be done. He has.
But it's a registration cancellation.
It is?
But registration cancellation of GST for non-filing.
You have the earlier judgments.
My lord, I gave it. I have another copy.
লিখে নিস लिखे नहीं এটা this was mattered original petition.
Lordship, item 22 is my petition. In this matter, my lord, I am led by Mr. Sabyasachi Chaudhary. He's not there tomorrow, my lord. Can this be taken up on Thursday, be in the list on Thursday? Because it will now appear tomorrow.
Tomorrow, if it is called on, you pray for time.
Very good.
I am mentioning upon notice, my lord, the interim order is going to expire, my lord. If your lordship kindly keep
extension again.
not on 18th, if possible, my lord. If the matter come on 18th. No, if the matter can kindly come on 18th. Interim order is expiring. I'm extremely grateful.
Mr. Mayor, extension of interim order, item number 1.
But I'm waiting for the response.
The matter is expiring in the month of this month, December, Your Lordship. The one difficulty is that despite of the stay, Your Lordship, they have just issued the 271 proceedings, Lordship.
Why?
They have given the notice. On 10th, we have received this
It's
notice.
not proper.
Understand.
Why are they doing this, Mr. Dudhoria?
But I had no knowledge
There
about
is an order of
Yes,
stay.
I understand. Yes. I didn't have knowledge, man. This is the first time I came to know about it.
Yes, on 10th of December, we have received it. The latest one.
It says restraining the respondents from proceeding any further.
Yes. It's there. It is there.
It is there.
Your Worship, further, it's a very small issue is involved in this matter. So earlier also it was
The Lordship
heard.
can clear out the matter but after vacation or any day, or can fix
It can be fixed after that.
after the vacation. In
The
the meantime,
affidavits are complete.
no, there was no direction filing.
There was no direction for affidavit.
It's not required also.
There was no direction, Lordship.
End of this month. The affidavit of opposition has not been filed.
You are there?
No, Mr. Bhattacharya and Mr. Kothari are appearing for state and health sector.
Oh, I had appeared. 2nd January 2025, I find my name in the order. This matter stands released from this list.
We missed the first order, I saw the last order. It's the first order, my lord.
कोई আগের ম্যাটারে আমার নাম ছিল না তুই দেখে নিন তো
This matter was heard by your lordship, my lord. I was applying the matter, my lord. He was, but this is, my lord, that according to him, my lord, there was no nexus in the, not.
What are your points, Mr. Agarwal? You said there were several points.
Yes, yes, yes.
There is an allegation that I have taken cash loan. But there was some search and seizure action in the Capera.
You are challenging 148A3.
Yes.
There was search and seizure action at the money broker place. And on the basis, allegedly on the basis of some documents, the department is saying that I have taken cash loan. And my lord, the position of the money broker was provided to me and the purported information was provided. Nowhere my name has been figuring. And in the information, some rukas are also reproduced, wherein also my name is not appearing. Now, they have prepared in the purported information that they have provided to us, they have prepared a table. And in the table, admittedly, my lord, somebody else's name is there, and they are grouping it under several persons' name, where my name, according to them, is appearing at the top. In the table, my name is also appearing, oblique. Several other names are also there. And at the threshold, in the notice issued under 148 capital A, the case of the AO is that the company in which I am the director, they have taken loan. So therefore, according to 179, ultimately the company will be taxed or liable for the cash loan. Therefore, he is jumping the gun and coming to a conclusion that why to take so much of burden or step. At the threshold only, I will invoke section 1. So and if we look at the information, there they have used the word potential, probable, all these words have been used. As that means that the department is also not sure.
At this stage, they are not required to be sure.
Yeah.
So, at the stage of issuance of notice,
Water has flown down the river Ganges. It has been a subject matter of adjudication by
still, but if they are sure at this stage only, there will be no requirement of assessment. Assessment proceedings.
I put down, my lord, but we all know, my lord, we are all follower of judicial discipline. I may not agree with particular decision, but I have to go down. My lord will have to, 100 tribunal members will have to go down before my lord's order. One judge of single judge of High Court, that view will prevail over 100 tribunal members.
Unless it is set aside. Unless it is set aside.
Unless set aside by the higher court. Now, the judgments which are holding the field, passed by the then Honorable Chief Justice Judicial Bench, presided over by the
This one which you gave last time, Gurkar Gopal Dalmia.
One more judgment is there that light nexus. But my case goes beyond this. My case is on a better footing, in as much as my name is nowhere appearing,
And for their department, for the first time in my life, I have seen they are clubbing all SSCs together and they want to tax me for that. No, this is not permissible under the law. Even for the time being, if we don't refer to Girdhar Gopal Dalmia, otherwise also, at least that material should be there where my name is appearing.
Yes, yes.
But admittedly, the name of they are saying that company has taken loan. Company is having several directors. How come one person be liable for the and on top of that, my lord, that live nexus theory still prevails. It is the income which should have escaped assessment. Taking of cash loan does not partake the character of income. This finding is from para 7. This was the second round of litigation. And in the second round, the order was the copy paste order of the first round. There you go. At para 9, the significance of the word potential and probable. And in my case, also same words have been used.
Yes, in the order. What is your case?
My lord, in my case, kindly see, my lord, table starting from page 92. Para 19, my lord.
Para 19. Para 19.
This is the purported information which has been shared. So, two names, Mayank Agarwal, Murari Lal Agarwal, Maya Fashions Private Limited, Selja Highlight Private. My lord, I admit that Maya and Selja are the private limited in which I am the director. ML Agarwal is my neighbor. He is not my distant relative. I took the instruction from the client. He is distant relative. He is having a shop nearby. So everything has been clubbed. They are saying oblique. There is no provision in the Income Tax Act that one person will take the responsibility of all and sundry. With the corporate bodies, in which I am the director, they are a separate entity. Day in, day out, department is proceeding. Take these initiatives wherever those names are appearing. How can you club everybody under one head? You issue notice to 10 different people. If my name is there, issue to me. But making the figure such huge, all and sundry are brought under my umbrella without any rhyme and reason. And it has no sanctity of law. And they have used the word as paralyzed potential lender or borrower status borrower. Then provable unique names coming under different format of lender names, all are clubbed under it. So probable potential same words are used as in Girdhar Gopal Dalmia. And on top of that,
Para 9, which page?
92.
Para 90, page 92 is para 19. You said para 9. Potential lender.
Potential lender, then probable unique name. Same words are as I think this has become the universal practice among all the. But it is the same information being circulated. And that, see the working table, my lord. Working table next page, borrower name.
Yes.
Not very
Himaya.
name. There's Samaya, and I have scanned through the each and every page, each and every entry of the table. Nowhere my name is appearing.
Yes, your name is not there.
It is not there. That is my reply. What these issues I have highlighted, which has not been dealt with. What is the reason why you are?
Where is that?
Lord, my reply is that page number 141.
Page 141.
Firstly, my lord, at page 143.
143.
My lord, just above Ashish Agarwal, third line in this regard, it is submitted before your honor that though your questions have relied upon the above information material in the notice, the above seized material under question has not been provided to the assessing the so-called notice. And last parameter, the income tax authority can gather materials against the assessing at its back, but he cannot use the same without giving an opportunity to the assessing to rebut the same. It is the duty of the department to allow the assessing to examine such documents without which no adverse inference can be drawn against the assessing. The case laws have been relied upon. Thereafter, at page 145. Without referring to the above, it is stated before your good self that along with the aforesaid for notice, your good self has provided us copies of two statements recorded under 132(4) of persons, namely Kumar Sankar Kasera, Praveen Kumar Kasera. In this regard, it is submitted before your honor that we have gone through the entire statements of the aforesaid person. In the entire statement of either of the persons, there is no reference of the name of the assessee or the two companies in which assessee is assisting director, namely Maya Fashion and
Telegram.
Then, my lord, at page 146, last line, it has been further stated on the statement provided to us that there are some reference to rough smoking usage in the service statement, which are very heavy and unclear. We are able to determine that there is any reference of the SSP or the company's which is the entity. So it cannot be said that the transactions mentioned in the appropriately to relate to the SSP. Your honor has not brought on record any material evidence, statement or document which can prove that any abbreviation relates to the SSP or the company. We have failed to understand as to how the department has calculated that the names mentioned in the statement relate to the SSP or the relevant company. Before proceeding in this case, we request your honor to please provide us a basis on which you have concluded that the alleged cash loan has been taken by the SSP or the company with which he is a managing director. It appears that the transactions made by some other person has been attempted to be linked with the SSP who has no link or connection with the broker.
And how has this been dealt with?
Yes, have not at all been dealt with. My learned friend can.
I'll show. But first, एक बात करें सुन जाता है इधर फर्स्ट এটা কি অর্ডারটা না তাই তো তো না দিতে হবে আমার দেওয়া আছে তাই তো
Then page 152, second volume. Para A, is further submitted to put on that we need to understand the nature of your allocation, whether the SSP is a borrower or lender. as from the documents made available to us, nowhere it has been mentioned as to the nature of transaction, whether it is known, given or taken. Thus, we also recommend it provide us with the intent as to whether the transaction is known, taken or given, as your honor is also not certain about messages of transaction to prove a lack of sufficient evidence in your information. And I have said section 179 also, which is you has referred to is the scope of at least 152. Without reaching to the above, it is further stated before yourself that from your scope of justice, one fact is very clear that the alleged cash loan of 55.10 crores has been taken by a company, Hassan Samaya Hassan and Selja Highlight. However, the case of the city has been proposed to be reopened by invoking section 179 as well. The managing director of the aforesaid company. Now, the case has been quoted where if you can see from section 1 clearly says, notwithstanding anything contained in the company's act, where any tax due from a private company in respect of any income of any previous year from any other or from any other in respect of any income of any previous year during which such other company was a private company cannot be recovered, then every person who was a director of private company at any time during private shall be personally liable. Only when the tax cannot be recovered from the private company. Further, what is of paramount importance? My lord has been hearing, and my lord has also argued this 148 matter. My lord was well aware that it has to be information should suggest that income chargeable to tax has to be done. It has to be in the nature of it. Now, if the loan transaction is recorded in my bank, then by deeming fiction, the law says that if I don't prove the three ingredients which are required in section 68, then it is presumed that my money has come back in the book. By deeming fiction, it will be added as my income. But where the loan admitted, department case is that I have taken loan out of which are not recorded. In cash loan are never recorded in the book. So, if in the nature of loan admittedly, then where is the question of income escaping assessment? I can be penalized. Because there is a provision that if I take cash loan, because it is the statute discourages proliferation of black money. Cash means there is a proliferation of black money. So to penalize such assets, the person who is taking loan in cash, section 271 capital D can be and 100% of that amount can be imposed as penalty, which they have already done now. My lord, I have annexed the penalty order also. Page 191.
Page 191.
So that is the final conclusion, whereby the 100% penalty of 55.10 crores has been levied upon me. So I am a dead horse. Cannot beat me again and again. Being imposed
In respect of the same year
in respect of the same
and same transaction.
transaction, same amount. My lord can see it is the same amount, same They have reproduced all these documents in the penalty order, which they have, which is there in the permissions provided.
And this this penalty proceeding arises out of which assessment order?
Look, independent of any assessment. As I said, my lord, if I take cash loan out of it, yeah, I have to be penalized for it because the statute, they in their wisdom are well aware that such loans do not take partake with the character of income. So, but we have to prevent proliferation of black money, so 100% penalty.
This aspect also you brought in your response to the show cause.
Just I have.
No.
I don't think so, but this is a small part of the entire submission. This is staring at the face. In the petition, I have annexed it, and by way of my that only when income department has to make out a case that it is in the nature of income. Then only they can
already he has penalized one. Then why for the same transaction once again?
Different nature of problem. May I just, my lord, will kindly allow me to, my lord, let him come. I'll place something, my lord, on my own.
Well, this life nexus theory in the case of present law has also been approved by the division bench.
Yes.
From para 5 onwards, the reference to CBDT circular has been made. And at para 6, the finding on the circular is that he has to make independent inquiry. Just we cannot copy paste the information that he received. Then Divya Capital, this Delhi High Court decision has been referred to, wherein first time Delhi High Court has deliberated upon the significance of the new terminology. Income, the information should suggest that income chargeable to tax, that live nexus theory has been affirmed. And our division bench also is affirming the theory of live nexus. So I have here, there is a missing link. Live nexus is totally missing. Number one, nowhere my name is appearing. Number two, the fact of taking of loan, the case of the department, I have taken cash loan. So it does not partake the character of income. So therefore the entire proceeding falls flat.
Yes, Mr. Bikaria.
Lord, in this case, my lord, a search and seizure was conducted in the Casera group in the year 2018, where, my lord, certain rukkas were found. In the rukkas, my lord, it is specifically stated that Simaya has taken cash loans from these cash deposits. Now, my lord, Lordship will kindly have a look at the rukkas first, my lord. In the rukkas, 252, Lordship will kindly have a look, 251 to 52. Page number 251, Lord Timaya received sum of rupees 25,000 such and such, Timaya proprietor, and Lord, he is the managing director. My lord, the Mayank Agarwal. These are the from HM Singhania.
Here also my signature is not there.
Yes.
Yes. Now, my lord, Lordship will kindly see the first, Lordship has seen. Lordship has seen, my lord, the 148A1 notice from Lordship has seen, my lord, page number 24, my lord. Notice starts at, my lord, page number 23, page number 24, my lord, where it is specifically said on the basis of this information, my lord, I'm just reading, my lord. Credible information flagged with the risk management strategy formulated by CBDT under such the formation of for the financial year 18-19 assessment 19 has been received from to the department such and such. The source of fan Uma Shankar Kasera, cash loan received such and such. The search and seizure along with the survey operation was conducted on 2018. During the search and seizure, some equity documents, the Rukas are found. On analysis of the seized documents, it was found that the Mayank Agarwal, managing director of Maya Fashions Limited, Mr. Shailaja Haidas Private Limited, received taken a cash loan of rupees 55 crore 10 lakh through financial brokers. It is also noted that section 179 of the income tax act that specifies certain liabilities of the director provided in the private limited company, which as under notwithstanding anything contained in this company's act where any tax is due from a private limited company transfer the income.
Yes, I've read this.
The Lordship will kindly come to note the page number 85, the modus operandi. Page number 85. Yes, page 85, paragraph 3. Modus. There are basically three types of persons involved in the unaccounted cash loan transaction: lender, borrower, and finance broker acts as a link between the lender and borrower. The cash loan transactions are arranged through brokers in lieu of a certain percentage of brokerage. The brokerage earned in checks is only entered into the regular books of accounts, whereas the brokerage received in cash was not brought on regular books of accounts. So majority of the transactions are in the cash, which are not brought on the regular books of accounts. By these parties, the brokers are running a parallel economy in the arrange the books of accounts between the borrower and lender. The financial brokers keep the regular touch in the modus operandi. Your Lordship has seen. These are the modus operandi because these they never brought on books of accounts. These are cash transactions. My London friend says all are there in the books of accounts. Had there been no such and seizure in the case of a Casera group, and had there no records are found, but these amounts can't be in the books of accounts. Those transactions, since those are in cash and unreported. Lordship will kindly see. Lordship will kindly see page number 88. This is just example of Rukka is there, no? Page number 88. Yes. The above picture of a Rukka is illustrated for the purpose of explaining the modus operandi of cash loan transaction. The cash loan amount is 25 lakh. The Vikram Forging Allied Permittivity is the borrower, and Sunita Agarwal is the lender. Yes. Here, my lord, Lordship kindly have seen this Rukka, where the borrower is there, my lord. Borrower is Vikram Forging Allied Limited, and is the borrower, and Sunita Agarwal is the lender. Srimati Sunita Agarwal ke Vikram 14 ke
Where are the Rukas of this case?
251. These are the legible, my lord. There are multiple Rukas, my lord. And 251, 252, 253. Yes. 251, Lordship will kindly. But H.M. Singhania's name is there. Received rupees 25,000 suggested from H.M. Singhania. Suggested.
Where? 251.
Page number 251. These are the legible copy of Rukka's. The Simaya Fashion name has been there. Yes. But yes, that is there. Again, your Lordship kindly come to page number 92.
Page 92.
Acha. Well, Lordship will kindly come to page number 63. Sorry, my lord, I'm troubling your Lordship. Page number
63.
Yes. Question number 28.
63, question number 28.
Yes. Please go through the branch of seized bunch of loose sheets such and such identified. These pages are Rukka transactions, and all these details of transactions contained in these pages are summarized in the tabular form as under. Lordship will kindly come to the next page, my lord. Lordship will please, my lord, serial number 2, my lord, where H.M. Singhania's name is there, my lord.
Yes, but where is the name of the petitioner?
Petitioner's name, petitioner is one of the managing director of Simaya. Main thing, the Simaya fashion, Lordship will kindly see page number 92, 92 and 93, 92, 93, the columns, page number 93, Lordship will kindly come. Page number 93. All these, I'm so sorry. So sorry.
Yes.
What I was trying to establish, from the page number 28, what I shown to you, question number 28, what I shown, this is, the statement of a Kasera, where he has says, this fund is routed through H.M. Singhania, that through the Simaya group, and Simaya, the Mayank Agarwal was the MD of the Simaya. Lordship will kindly see, page number 93, 92, that paragraph number 19, where, page number 93, we have specifically stated, how the Simaya has taken loan from Aditya International, Aditya, Lordship will everywhere, Lordship will see, cash deposit. Simaya's name is there. Now, if Lordship will kindly see, now Lordship will kindly come to page 105. Where, the Lordship will kindly see page number 105. 105, last but one column, your Lordship will see, that H.M. Singhania's name is there, how this, the Rukka which I have shown to your Lordship, page number 251, that is, mentioned here, this amount is being taken from H.M. Singhania. Now, if you so yes. Here the link is the Kasera says H.M. Singhania is one of his operative. Through H.M. Singhania, this has been done. The entire, and Lordship will kindly come to page number 137. Now, what my learned is saying, he has been thrown in dark. He has no documents like given everything. Lordship will kindly see page number 137, supporting these documents. Lordship, what we have stated, the supporting seals documents, papers are being voluminous in nature and do not be uploaded along with the dissemination note. The supporting seals documents, papers will be provided and as and when required for further investigation requested under. But we have given them the contact number, email, and they have not asked for any documents. Now they are saying, these documents are not provided to us. Let him show, that they have applied for, they have asked for any documents, that these are documents they want. In their so-called reply also, we have specifically said these are voluminous documents. If you want any documents, which you can always ask from them, they need not ask for any documents. Yes. But here the prima facie link has been shown, and Lordship will kindly have a look at, then your Lordship will kindly straight away come to the order itself. Order. Order starts at page number 160, 148, A3. It's a detailed order, and your Lordship knows, when a detailed order, it's basically, in basic proceeding, whether it's not a final or any demand has not been created, nothing has been, your Lordship knows, judgment of Ansul General, I'll place that. Lordship will kindly have a look first, page number 160, the order. The credible information flagged with in department strategy formulates, Lordship, that notice,
page 160.
160, my lord, 148 AC.
Page 160.
Yes.
Yes.
My lord, this, my lord, 148 AC notice, I will not trouble, my lord. My lord, how, my lord, the credible information was received and on the basis of it, my lord, and thereafter, my lord, his reply was also duly considered. Lordship will kindly come to, my lord, I'll relevant judgments are also shown. Lordship will kindly come to straight away, my lord. No, 178. 178. ঠিক আছে মানে আমাদের কনক্লুশনটা 184 Miller, page 175, will kindly see. Yes. Page 175.
Yes.
Miller, yes. Miller, the adequacy of the information provided under 148A1. It is respectfully submitted that due to that the assessed contention that these materials were not supplied along with the proposed notice under 148 devoid of any and based on a interpretations of the judgment reported in the Union of India versus Ashish Agarwal. In the same decision, the Honorable Supreme Court directed not only those materials which from which the basis of the belief of escapement of income could be provided to the assessor. The proposed notice dated 27 March 2025 issued under section 148A1 along with the dissemination notes uploaded on the Insight portal clearly discloses the nature of information, the parties involved, and the quantum of cash loan, such as rupees 55.10 crores, and the connections of the assessee with the same as beneficiary of the financial broker. Therefore, the core material forming the basis of the proceedings are duly shared. My lord, the information received from the risk management system channel flagged intelligence under the risk management strategy formulated with the CBDT details of the cash transactions along with the PAN and the PAN of the source party Uma Shankar Kasera and the transactions value and the involvement of the assessee as beneficiaries were disclosed. The assessee was asked to furnish corroborative evidences, books of accounts, and explanations. This satisfies both the statutory conditions. Milord, here, Milord, he was asked to produce the document, Milord, he did not produce. Milord, the case law cited, Milord, we have also given the Milord. So, Milord, then Milord, doctrine of probability of under section 148A of the Income Tax Act, it is noted to strike the balance between the rights of the assessee and the
Yes, that's finished.
Yes. Now, straight away, Lordship will kindly go to 180, Milord. Milord, on the nature of modus operandi, Lordship will kindly see page number 180. The assessees claim that the case is based on the general modus operandi of substance. It is submitted to the flag case of the investigation separately, while modus operandi forms the investigation background. The assessee's PAN name and entries have been found mentioned in the investigation output. Hence, the here Lordship will kindly assessee's name, found entries have been found mentioned in the investigation outputs. Therefore, the reopening of the is not. Lordship will kindly come to page 182. 182. Yes. The assessee's blanket denial of any link with the transactions in questions cannot by itself rebut the credible or specific material gathered from the search and seizure operation and flagged under the risk management information strategy, which is part of the department has not acted on any assumption, conjecture, or surmise, but on the specific seized RUCA documents. Lordship kindly analysis of the seized and impounded record, the statements of records of the financial brokers, PAN linked with the metadata pointing out the assessee company. The burden of establishing the initial nexus of understanding the 148 stage is not once the credible, tangible information were given, but the Rajesh Javeri's case, I'll say that case. Well, I'll place certain judgments, Rajesh Javeri and other judgments. Then your Lordship will kindly kindly come to. Acha. Lordship will kindly come to page number 185.
How long will you take, Mr.
It will take some time because I have to.
How long? Still how long?
Half an hour.
Half an hour will be too much. 10, 15 minutes.
Acha, 15 minutes. Because I have to place
Because
this.
everybody else will be held up.
I understand because I have to
Anyway,
place
next week close it so that
yes,
I
yes,
can also
next week I'll close. Well, I'll place a certain three judgments. I'll place.
yes, you place. I'll not rush you, but
Yes, yes.
be a little faster.
Because it's a actual aspect. Now I have to show certain doc.
When can you come back so that I can take up the next matter?
But
the other two matters are similar. If one is done, the other is
there are certain differences. Yes, yes. They have not given any reply in those.
The basis to challenge the proceeding is the same.
Yes, yes, yes. And I will also cite. I will also come the penalty posting. Your lordship question. Not it is on a. I'll satisfy your lordship. Next.
Liken it. Heard Mr. Agarwal, learned advocate, appearing for the petitioner. Not filed the reply.
In one case, penalty.
Only this case may not penalty.
No, in two cases, 2 years they have imposed penalty. 1 year they have not.
And in the other two cases, in both the cases, you have not filed reply.
They have not filed any reply in both the cases.
Very good. Only on that aspect, you show me the papers on the next day.
I'm not. I'll take some time because I have to all the factual. Now I have
completed in 15
yes,
minutes.
Yes.
Hurriedly,
I'll
not required because almost all of it I have read because it was I was taken through the documents by Mr. Agarwal. So
I'll cite three judgments.
Yes, the judgments you cite as many as you want.
Lord, only it will take 1 minute to conclude the issue, and I will go down. I will concede if one document just so that it is in mind. The fact that company is a separate entity. There are 5 directors. Why I will be responsible for others? And in most of the cases, I am not even the signatory. First time in my life, I am seeing that everybody is brought under my umbrella. Either I am, they should allege that I am penamdar of everybody. This is my transaction only. That no government.
Only on the ground that he is the managing director, you are proceeding against.
Yes. In his books of accounts, all these transactions could not be unless the such and such took place and the rukkas were found from the rukkas Istimaya fashion where he is the managing director, So
the managing director of Istimaya Fashion, and what about Shalja?
Shalja also these two matters.
Shalja is also a company, private limited company. Yes, sir. You are managing director in both. In both.
I have come here for there. Still they can amend.
4-5 का ये कर दे. 4-5 same order करे.
1920 still they can
separate order. Separate order. 4-5 also I am passing the same order separately.
Number 6.
Banerjee,
you were saying that Mr. Banerjee, Lord, in this matter, Mr. Oran Banerjee is appearing for state, Lordship. Now he is not in court, Lordship. I am prayer for only adjournment, Lordship. Lordship, kindly keep it on Friday, Lordship.
Friday will be difficult. We'll have it on 23rd then, Tuesday. 23rd. Prior to the vacation. You conclude hearing, I'll then deliver this. Day before the last, penultimate. 24th also we are okay. As prayed for.
Penalty under the.
You are there. Who was appearing for the respondent?
Anyan was supposed to address, your lordship, here the primary ground of challenge is that we've not received the show cause notice, your lordship, and
Yesterday also Mr. Sanyal was not here.
Yes.
Where is he? I'm passing it over, see if he comes back. Pass over to him. Next call. Yes, Mr. Raju.
That I don't have an alternate escalation remedy because I cannot meet the requirements for public. I will just take time. That's what is faced with current condition. Over here, my leg is a house, but I joined this company in 2002 as a junior executive. The company was Gupta Infrastructure Part Limited. Gupta Infrastructure Part Limited manufactures electrical conductors, which conduct electricity, the RF figures, which transfer electricity from different districts. Now, one of the actors which are used to manufacture this particular final good is a composite force, copper composite force. That both were imported from United States of America by the company. Now, during the period 2020 to 2024, the company had imported those goods from United States to India. The job of the petitioner was to check the details that is provided by the foreign exporter and match it with the details over here and pass it on to the custom house details as a senior executive of the region. The department disputed the classification of those goods, the input. The company was paying duty at 7.5%. The department came to a conclusion that it was wrongly classified. It ought to have been 7.5%. It ought to have been 10%. So when the department issued a show cause notice towards the company demanding the differential duty along with interest and penalty. Separately, on the same show cause notice, it made allegation that I am liable to penalty under section 150. Now, I find the reply, the company find the reply. The total demand of that in this case is a sum of 67,22,000. The demand which is based on the head of the company is a sum of 57,22,000. Now, the order was passed on 31st May 2025, which confirmed the demand of 67,22,000 against the company. And in the employee of the company, executive of the company, it imposed certain penalty under section 140 equivalent to the value of the goods. The value of the goods over here was a sum of 20 crore
28,000 something. He has imposed on an employee of the company, which because I was an employee in the company, on whom there are such a huge demand has been imposed. The problem is because today, the last first, I'm not engaged with that company anymore. Second, the last salary from that company that I have given my what that something on and gross salary of that company. Because today I have total assets, I give it today I have a total asset of 5,66,000 and liabilities of 3 lakh something. With these financial pillars, such a towering financial amount imposed on the employees of the company who just had a mechanical job. It was not the case that it was my duty to determine the classification. It was not also the case that if I told my company that to classification B, go on to classification A, they would have gone and chosen option B. It's not that I was a decided factor, not in the case. I am a person who has technical know-how with regard to class. My job role was to see whether the figures provided for the exporter was correct or not, whether they match the figures or not, and that is the mission. It's faster maximum. Right of these facts today, without application of mind, without following principles of practice fairness, today I understand section 114 permits before the negotiation of connecting to the value of the goods. But my contention is that it has to not be with you in my case. Because today the value of demand of 67 lakhs the company is giving this separate. Penalty on the employees who are some of 20 crores well, is not at all justified. Not at all justified, so I should try if I think all your losses I can keep the order. And you see as on what basis is this penalty supposed to be imposed by this order? The order has that can't be a reason that I can't pay and therefore I don't know. I don't can consider any of these, we want to put an appeal. To consider any of these filed by your order without one piece for those games from the court by law. Kindly allow the court it's not a privileged that all the other maybe he has not come up with any point to provide other than going goes into the bed. So I gave it at this point. But these students I can't get.
Why should this order not be passed? Of asking him to refer the appeal without insisting on prediction. Complete waiver is an impossibility. But then in that case, you'll have to challenge the statute. If you say that that is. Yes. Next. Mr. Raju, in that appellate side matter which was going on at 2 p.m., can you call the other side, because the second matter, the same order will go, or what? You ask him to come. Yes, but still, Mr. Salve's name will be there or not. Somebody should come and say that. Ask him to come and say that, because on oral I'll not. It's page 326.
Yes, sir. Volume 3.
Yes.
Milan, this is my statement of assets as on 4th September 2025. Milan, at the middle of the page, Milan will see is my bank balance, which is abysmal. Milan, thereafter, we'll see Milan, my assets which I hold is a scooter and 200 square foot parcel of land in Odisha.
But who will make this assessment? How will I rely on this?
Milad, the point is, Milad, I'm trying to stress on is, Milad, the order in original, which is 114 AA, good or bad, Milad, I cannot prefer an appeal. It is not within my financial capacity to prefer an appeal.
So say that it is not within your financial capacity. This statement of yours will not suffice, because I don't know who is the author of this statement. What is the credibility of this?
Yes, Milad.
How to rely on this statement? How will I assess the worth of this statement?
Milad, the previous page 325 Lordship will see. This is drawn by a chartered accountant, Milad.
And how do you say that the order is wrong? Can you say that the order falls within any of those exceptions where appeal may not be required, alternative remedy will not be there? Then in that case, your case will be on a better footing, that it falls within any of those 4 exceptions where it can be entertained despite availability of alternative remedy.
Yes, sir.
If this is one of your points, then in that case, we need not go into it. We'll see the challenge to the order and see whether it satisfies the exceptions.
Yes, sir. I'll come to the second point. My first point is, subsequently on page 329, I have also submitted an affidavit reiterating as to what are my assets and liabilities, my lords. I have also put forward an affidavit, apart from making pleadings in the writ petition. Milad, second, with regard to what is wrong with the order, Milad, my submission, Milad, it is patently illegal. Because, Milad, over here, Milad, there's a classification dispute between the company and customs authority. It is not the case that I have been evading duty. The difference of customs duty is 2.5%, which equivalents to 67 lakhs on the company's head. Yes, Milad. Now, Milad, if your lordship allows me, I will go through the statements, all the summons statements that has been recorded, and I will show, Milad, that the penalty which is governed under section 114 AA cannot be attracted in my case, especially against me, and that the order that has been passed is patently illegal, Milad. Because today what has happened is, because Milad, it is patently, I cannot prove that hearing was not granted or I did not receive the order. That is part of facts. I have furnished a reply.
Can you go to the extent of saying that the order is without jurisdiction to that effect?
Milad, it is without jurisdiction because it's patently illegal. I cannot say that the person did not have the power to impose that quantum of penalty. It will be wrong of me to say that the adjudicating authority cannot impose that much quantum of penalty under 114 AA. 114 AA permits him to do so. Milad, but that Milad, that
114 AA could not have been invoked
in this particular.
Some other provision could have been invoked for position of penalty.
Milad, I have not assisted the company to evade payment of duty. No
but
portion.
That's again a factual inquiry.
It is a factual inquiry, Milad. That is the problem. But Milad, if I can draw your attention to section.
Mr. Kundalia, in a case where a person is impecunious and he suffers an order of this kind, will be remediless. That can't be the intention of the statute. Suppose a person has been, I'm not talking about this case, particular case which is found to be genuine, the order does not satisfy any of those exceptions within which a writ can be entertained. The person is absolutely a pauper. Now, will he be then remediless because he cannot approach the stat? High Court will not entertain. That can't be.
First of all, I understand what is calling from my lord. My lord wants to say, in spite of everything,
Yes.
he is taking some injustice is being done.
Yes.
To some person, even though he is an accused, even though he is
No, it is not that. It is not that. It is.
taken to that high level.
No, the question is not that his grievances are being redressed by the writ court. The writ court is only opening the door of remedy, where he can approach and seek redressal. If the appellate authority dismisses his case on merit, it's well and good. But merely because he is not in a condition to meet the mandate of statutory pre-deposit, will he be put out of the zone of remedy?
These are the questions that were there, where the challenge that the 5% the judgment that my lord wants to respond by two. I'll bring it on the thing. But apart from it, for a moment, let's forget. Is the writ court today in a position actually to know whether he's in a proper state?
That definitely will not, but then there are means. Again, we can send it back to the sextat, who will then examine and say if it is, if he is found impecunious and if the law permits, then sextat will proceed to determine the, hear the appeal and decide the same on merit. That exercise writ court and undertake. But then at the threshold, can it be stopped? Of course, there are judgments to that effect also, that complete waiver in certain situations may not be permissible. But if a situation of this nature comes to court, what will be the
Court has more or less to a certain extent, I won't say completely, to a certain extent, there is the issue before the writ court under the court nomenclature. Of course, there exceptional situations are always there. Now, whether the discretion to allow those exceptional situations is completely the power of the writ court. There is always that power that is available to the writ court. Now,
availment of remedy, seeking redressal will be a facet of fundamental rights. So this will definitely go within. This will be appropriately within the infringement of fundamental rights. That is one of the grounds for invocation of writ jurisdiction.
So, here primarily, what is the case? The case is the custom. It has of the declaration of goods which were classified in a particular manner, whereas others are classifying it in a different manner. They themselves are classified in a different manner, which they ought to have, but they have classified it in that manner which is there, which is got by the department at the behest of this person who was in charge of this person. There have been statements made, there are statements based on that. It was found that this person was a was world. Now today, once the penalty, rightly wrong, because this subject to appeal, they have their right to go on appeal. Rightly wrong, the situation comes where he says today, I'm an employer. Now most of the matters before my lord that will come before my lord with regard to customs or any other matters of this nature are that I am an employee or I am an employee of the government. I am an employee of a small private company. I can't be drawing more than 20,000 rupees. I can't be drawing more than what the government has given. But this doesn't stop the course of law to continue. The course of law, the statute has been constituted as a deterrent also in this case. It is actually in certain cases, particularly economic offenses, these are in the nature of deterrence also.
Bring the judgment of 7.5.
I will bring. Next week, my lord, I will speak.
Heard Mr. Raju, learned advocate, appearing for the petitioner, and Mr. Kundalia, learned advocate, appearing for the respondent customs authorities. Full stop. List this matter for further consideration on December 23, 2025. You have contacted? Please be here, both of you.
For the petitioner, Your Lordship, in this matter, the notice for hearing was not served on the petitioner. Your Lordship had called for a report from the respondent. Your Lordship. Your Lordship, the report clearly shows that it was not served, Your Lordship. It was issued, but it was returned unserved. Your Lordship, the show cause reply and the pre-show cause reply had my email address. The order in original was served to me by email, and subsequently the appeal order was also, after 4 months delay, was served to me by email. So, Your Lordship,
You are there.
no attempt to send it by email was made, Your Lordship. And Your Lordship, my office is open.
Paragraph 3.
We are given all our acknowledgements that all the request names were returned back to start returned back. They are thinking of that they are not upon them to justify or take steps against the postal department. We are in charge of our responsibility by on behalf of the appellate authority by giving them notice, but somehow they haven't done.
Your Lordship would kindly take.
Now at this point of time, they are saying that the address we have address, whatever address is there, they have been addressed and envelope your document signing. We are in charge of budget with regard to the ending of postal receipts, postal envelope, informing them about the date of hearing and
Your Lordship would kindly take up section 153 of the Customs Act, Your Lordship.
But we are not buying any
I don't need to, Your Lordship. I will.
Section 153.
Your Lordship, section 153 provides for the mode of service of notice, order, etc. Your Lordship, we are concerned with subsection 1B. Your Lordship, the provision is an order, decision, summon, notice, or any other communication under this act or the rules made thereunder may be served in any of the following modes. Namely, Your Lordship, I am coming to B, by a registered post or speed post or courier with acknowledgement due delivered. Your Lordship, Your Lordship, I emphasize on the word delivered to the person for whom it is issued or to his authorized representative, if any, at his last known place of business or residence. Now, Your Lordship, with this, I also want to read subsection 3, Your Lordship. When such order, decision, summon, notice, or any communication is sent by registered post or speed post, it shall be deemed to have been received by the addressee at the expiry of the period normally taken by such post in transit, unless the contrary is proved. In this case, Your Lordship, the report itself shows that it was returned to the sender, returned back to the sender, and Your Lordship, the word used here in the 3 cases is issued, not delivered, Your Lordship. Now, Your Lordship, coming to the facts of this case, Your Lordship would kindly take my reply to pre-show cause, which is at page 34, Your Lordship. This
34.
34. Your Lordship would see that my email address is mentioned in the reply to pre-show cause at the bottom of the page, Your Lordship.
And how was this reply served?
Your Lordship, this reply, Your Lordship, I am not aware, but I participated in the show cause stage, and Your Lordship then replied to show cause notice at page 50, Your Lordship. Here also my email address is mentioned, Your Lordship. Now, Your Lordship, the order in original at page 50, Your Lordship. The order in original, Your Lordship, was served to me by email. That is mentioned in my memorandum of appeal at page 115, Your Lordship.
Page
115, Your Lordship. Your Lordship, fourth entry, serial number 4. Date of communication of the decision or order appealed against. Your Lordship, wide email, and from which ID it was sent, it is mentioned. $115, Your Lordship.
page 115.
5, Your Lordship. Serial number 4. This order in original against which the appeal was preferred was also served on me by email, Your Lordship. From this email ID of the government, Your Lordship. Now, Your Lordship, the order, the appeal order, which is impugned here, was also served on me by email only. Page 174. Your Lordship.
Page 174.
Second volume, Your Lordship.
Yes.
This order, Your Lordship, after a delay of 4 months, the order was served to me by email. And Your Lordship, the notice of hearing, Your Lordship, at page, Your Lordship, was never received by me. Only when I received the order, Your Lordship, at page 183, this is a part of the order, Your Lordship. First paragraph, neither the appellant nor the respondent appeared in hearing. And they have said that for the sake of natural justice, personal hearing in the matter was granted to the appellant as well as the respondent.
Which page you are reading, ma'am?
Page 183, Your Lordship.
Page 183.
83.
Yes.
First paragraph on the top, Your Lordship. Personal hearing in the matter was granted to the appellant as well as the respondent on 3 days within 1 month, Your Lordship. Neither the appellant nor the respondent or any representative on behalf of the respondent appeared in the hearing. Your Lordship, even the government was not represented. So, Your Lordship, it was not served. And the requirement is, Your Lordship, it should be delivered. And unless the contrary is proved, they had information that it is not being delivered. They made no attempt to send it by email, Your Lordship. They continued as if hearing has been granted. Your Lordship, the section is quite clear, Your Lordship. And Your Lordship, there are 5 modes of service. When notice is...
Page 174 was served through email.
Your Lordship, by email. After a delay of 4 days, on the same date, Your Lordship, recovery notice was also served. Your Lordship, recovery notice at page 186. It has been annexed at page, Your Lordship, it is annexed.
Page?
Page, Your Lordship, 174, then next page, 175.
On the next day it was served.
Your
August 23, August 13,
13.
This
And
is
Your Lordship, the appeal email ID is also given at page 175. Your Lordship, these days everything, Your Lordship, government orders are being exchanged on email. That is also an option under, Your Lordship, subsection C of section 153(1). Your Lordship, they could have avoided this by just sending it on email when all appeal is being filed online. Everything is happening online, Your Lordship. And Your Lordship, I had participated at pre-show cause stage, Your Lordship. And this I had submitted on the last occasion. And Your Lordship, thereafter, Your Lordship had called for a report. That since the conduct of the petitioner shows that at every stage he is participating, Your Lordship, here the dispute is a classification dispute. It is, the entire value is 1,70,000 odd. It is not even that, it is not the case that high value, it is a high value case. It is a dispute of classification which was raised after 2 years. Your Lordship, all I am asking is that the matter may be remanded and I may be given hearing and the matter may be decided afresh.
Yes, Mr. Banerjee.
Of the physical property has to 500 has been exposed.
Page 114.
115, 114 is actually.
Yes.
At 115 towards the bottom, consider 93. That is the.
Yes.
But thereafter, very system, thereafter, is a continuous in 172. Thereafter, there has been no interval in the part of the petitioner to assess or request by the board by the petitioner wants to contain that he is not received the notices for hearing or the outcome of the hearing, or whether any hearing was sought to be given. Thereafter, when everything was coming, was recovery notices were given. Thereafter, he started using the email format from his email ID. One thing you have also time to consider here, another friend has referred to section 153.
Yes.
It says that they will serve any of the following modes.
So one will suffice.
Only one will suffice, and if sent by duty to send to the last source address, and that can be a sufficient compliance with regard to service of notice. Until and unless contrary evidence is produced before your lordship. Now over here, the envelope, everything, what is there in my file, it is a government authority, it is not a private authority. So whatever government authority has done in due discharge of their official duty.
No, but Mr. Banerjee, if the notice itself comes back with the endorsement.
Postal department is not of the customs department. Postal department is of an independent.
Very well, then the requirement of receipt of the notice by the person concerned is not fulfilled.
My content of services is asking that I have done services according by the ordinary forces of the law is the law prescribed. Or somewhere manages the postal department and refuses to accept the payment.
That is not there in the affidavit. That is coming from the bar that I have managed. How can I justify your notice?
That is not for the purpose of.
Your Lordship, it is not delivered.
Why did you not bring it to the notice of the appellate authority that the proposed notices or all the notices which were served were not being received by you?
I have preferred an appeal. I am waiting for the hearing notice. It gets delayed. Your Lordship, sometimes matters are kept pending for years. So, Your Lordship, I did not receive anything. Only on.
Very well, we'll hear it. लिखे नहीं पर a report in the form of affidavit. বলছিলাম অ্যাপেলেট সাইডে 2 PM এ একটা ম্যাটার ফিক্স হয়েছিল। অ্যাপেলেট সাইডে যে ম্যাটারটা 2 PM ফিক্স হয়েছিল, যিনি ডিসকাশন নিলেন সেম অর্ডার সেকেন্ড ম্যাটারই হবে, সেম অর্ডার 1 and 2 সেম অর্ডার হবে, আলাদা আলাদা। এটা রয়ে গেছে কারণ yes yesterday also it very well, not a problem if I reach tomorrow. Thank you.